balance by, and you'll only owe them $42, I believe. Balance by December, how about the 22nd? Can you do that?
Yes, sir.
If you don't have the money, don't sweat it. Just call the court. We'll go on Zoom. I'll give you an extension, okay? But you have to call on her before the due date. Fair enough?
Fair.
All right. Good luck to you. Go down the hall, pay your other 50. I wish you well. Have a nice Thanksgiving. Rochelle Ellen Butts, 25R514310. And can I have Ashley Glover seated at the table, please? Ma'am, your name?
Rachel Butts.
All right. You're charged with open house party. You have the right to a lawyer. I'll be happy to give you. Do you want a lawyer? Okay. We'll give you a lawyer. And you can go out in the hall. Just be patient. There's going to be a couple others ahead of you. And then as soon as they're done, you can come in here. Thank you. Ashley Leanne Glover, 25R514382. How you doing, Ms. Glover?
I'm good, how are you?
Your name?
Ashley Glover.
You're charged with assault. I can't tell you much more than that. You have the right to a lawyer.
I know, I'd like to enter not guilty.
Do you want a lawyer?
I'm not sure, I've never been in trouble before.
Good.
I have no
Good.
idea how to go about
Well,
this.
then maybe you need a lawyer. How about if I give you a lawyer?
If you think it's necessary.
Well, you're charged with assault and I would get a lawyer if I was you. Do you want a lawyer?
Yeah.
Okay. We'll set you up with a lawyer. You'll go out in the hall. We'll see you back here either way after you speak with your lawyer and your lawyer speaks with the prosecutor. Harley Quinn Wakash, file number 25F244090. Your name?
Harley Quinn Walkout?
Did you talk to the prosecutor yet?
No.
Mr. Kaylee, can you hear me? Listen, I'm going to send this young lady to you, Mr. Kaylee. She's got a review hearing date today. She should have been sent to your, in fact, do you mind just coming in here? I'll hand you the file and you can walk
Sure,
in
Judge.
here and get her out of here. It's just a review and it looks like she's done everything, okay?
Absolutely. Thank you, Judge.
Thank you. Good day. Again, when he comes in.
Where you going to go, Steve?
You just move over just a little bit. He's going to come in, sir. You have to take your hat off, please. Stay right there and the prosecutor will come in and you can go back there with him. Actually, yeah, Jason Adam Roy, 25B149149. A and B. Your name, sir?
Jason Adam Roy.
You have a show cause for failure to pay, 213 on the A file.
Yeah,
You owe 327 on the B file.
you know, I'm really just so busy with work and taking care of my dad, I forgot about it. I really don't get paid until tomorrow.
Okay.
Okay.
You can't forget about tickets, though. Okay,
I don't
just
know.
hang on. How much you gonna be able to pay to me?
Pay it off.
You sure?
Yeah.
This is 213 plus 327.
Get paid good.
That's $540.
Sometimes pay it more.
Tell you what I'm gonna do. I'm gonna reduce your balance on the A file from 213 to 195, okay?
Thank you.
I'm gonna reduce your balance on the no insurance from 282. But you have to pay a clearance fee on that. So I'm gonna reduce that balance to 230, and you still have to pay the clearance fee.
Thank you.
So just give me a second. And all this is due on November 14th. So you're gonna come in, you're gonna pay 230 on the insurance plus your clearance fee of 45. That's 275. And then you pay the 195 on the speed. There's no clearance involved here. So what did I say? 275, 470 is going to be your total. Okay? So you bring that in tomorrow and then we're gonna give you a clearance. Okay? The clearance for the suspension, you have a suspension on your record. I hope you didn't drive here on the, no, okay. All right. Come on in with that tomorrow. We'll take care of it. Good luck. Brianna Morgan Cook, 25M567625. Your name, ma'am? Good morning. You have the money to pay all this?
Not today.
How much do you have today? Do you work?
I just started my job
Where?
at Acorn and Middleton.
What is Acorn?
They sterilize medical.
You don't have anything at all today?
No.
Okay, next time you shouldn't have ignored us. This just got
I
worse.
lost my dad 4 days after I got the ticket and I had to bury him with no insurance.
Jeez, I'm sorry.
So I'm just now getting my life back to where it was.
Balance reduced. I'll reduce your balance. You still should have called after. I get it, but I'm sorry about your loss. I'm gonna reduce this balance to 185. Can you pay $50 a week?
Yes.
Or not?
Yeah.
Okay. When can you start?
Thursday.
Tomorrow? I mean, next Thursday?
Yeah.
You pay 50 per week, beginning on November the 24th. How's that? That'll give you an extra couple days to get it here. You can pay online, but there is a fee when you're not paying it in full, just a small fee. They could tell you down the hall if you're interested, okay? If you don't have the money on any of your due dates, no problem. Just call the court. We'll go on Zoom. You and I, on or before the due date, 8:30 in the morning. Be glad to give you an extension, okay?
Thanks.
Best of luck. And again, I'm sorry about your loss. I really am. Sean Michael Bodenschatz. What do you,
I was looking to.
okay. 20R 511-802A and B. Your name?
Sean Bodenschatz.
Where you been? Where have you been?
North here,
North? What do you mean, north?
north of, I mean.
Riverview?
Because it's back 2020,
Yeah.
where am I been? Yes, I'm ignoring it.
What does north
For the
mean?
past 2 years.
Hang on, slow down. I don't know what north means. You mean Riverview?
North of here. No vehicle. to get down
Riverview?
here, So I'm sure.
Riverview?
No, I was living in Troy, but I was also living in Flint there for a while.
Did you call the court?
No, again, I was ignoring this one.
Thank you. Can't do that, son.
Not aware, yeah.
You got a resistant, obstruct, and a disorderly. You want a lawyer? I'll give you one.
Yes, please.
We'll set you up with a lawyer. Go out in the hallway. My court officer will bring the file out. And you will be set up with a lawyer. Just stop. Don't do that. You understand what I'm saying to you? Judges don't like that.
I've been taking care of other things the entire time. I got multiple other stuff on my driving record. I'm taking care of. I'm
Welcome to life.
driving for right now in.
Where? Good. With what judge?
Judge K.
Okay. Good. All right. Let's get your life turned around. Okay.
Hey,
Wakesh. Do you have the Cantu file?
I do, I'm logging in.
Oh, okay, no problem. Harley Quinn Wakesh, 25F 244-090. How you doing, ma'am? Your name?
Harley Quinn Walker.
Raise your right hand. You solemnly swear affirm under penalties of perjury, the testimony of given in these proceedings will be the whole true self you got.
Yeah.
All right, since you were in court and I sentenced you back on September 4th of this year. September 4th? Yeah. Have you been arrested?
No.
Any new charges?
No.
Congratulations to you.
Thank you.
Case dismissed, motion to prosecutor. I really wish you well, ma'am. Good luck. Thank you. People against Cantu. Francisco Elijah's Cantu, 25F 244-762A and B and C.
Good morning, Your Honor. Chris Bichette, appearing on my client, approaches and stands to my immediate left.
Sir, your name?
Francisco Gantu.
All right, what are we gonna do here today,
Your
Counsel?
Honor, I was recently retained on this matter. I have put a request in for discovery. I believe that there's going to be also a further request for body cams and the potential cameras around the surrounding area. I'm
Okay,
going to ask for an adjournment, Judge. A 2-week adjournment would put it on Thanksgiving, and unfortunately.
you don't want to be coming in on Thanksgiving?
I actually don't mind, Judge, but I mean, I don't know if you want to cover it. And then the next available date is the 11th. However, I'm not in the state of Michigan, so I was going to ask for the 18th. With the understanding that I'm not going to ask for any other adjournments. It's going to be a resolution or a trial.
Is it my docket any?
No, but I spoke with the prosecutor and he said he doesn't have a problem. You have an overlap.
Okay, I don't want to interfere with Judge Hessen's docket, okay?
We'll get it 8:30.
That's what I mean. I'll do that. 12:18 at 8:30 in the morning, but please be here at 8:30. I don't want to interfere with her docket, okay?
Understood. Thank you.
And so, sir, let me see your AA sheet.
I actually left one at home.
What do you mean?
To have, I already went to two already though.
Let me see it. Show it to your lawyer. Okay, I told you to go once a week starting October 3rd, right?
This is Recovery Community Center in Troy, Dan Trammett, of Recovery said he attended meetings on Wednesday, November 12th. That's what this indicates, Wednesday, November 12th.
I also went to one in Troy with my boss, but I left it at register.
Bring your paperwork, okay, make sure you bring it, keep them together. You should just use one, then you won't have two, then you won't forget one, right? December 18th, 8:30, we'll see you here. Thank you very much, Mr. Shemke.
Thank you.
Good luck, sir. David Istelart Gonzalez, 25W836565. Mr. Istelart, good morning. Your name?
Good morning, David is still alert.
So I'm a little confused here. Your probation officer again is who?
Emily. Emily.
You don't have sheets out here. What's her number again? Is it 253, Amy?
Yes.
Can you come in on David Istelart Gonzalez? He must leave the state. Thank you. So you say you want to leave. You said, I request a hearing and motion this court for the following relief. Consent to leave the state within the US for more than 1 week to visit relatives from December 15 to 25 to the 15th of February, 26. You're gonna have to be more specific than that. And where do you want to go, first of all?
We have not really defined as it depends on the weather.
Wait a minute, wait, keep your voice up.
Can you hear me?
Keep your voice up nice and loud. Where do you want to go?
It could be Florida or California, depends on the weather.
Well, you're gonna have to be more specific. I'm just not gonna say for you, you can leave the country between December 5th or stay in the country anywhere between December 15th and February 15th. That's 60 days. I don't know what time frame you want. I'm not gonna have a problem with letting you go. But you have to be more specific. I mean, you're talking about two places that are 2,000 miles from one another, if not more. 3,000. So when do you want to go and where do you want to go?
Probably going to be Florida.
Well, you got to be more specific with me. Ms. Tassino, your name? So he wants to leave between December 15th and February 15th, 60 days. He's saying for more than a week. He doesn't know where. He might be California, might be Florida. Now he just said probably Florida. So I need you to be more specific with me, sir. If you want me to reschedule this and you can think about it, I'll be more than happy to do that.
It's just that it's really, I don't have any instructions there, and I told Emily, I don't see any instructions how detailed you want this.
Say
So
that
do you
again.
want
Wait a minute.
it,
Wait,
do you want
wait a
it by
second.
day? Do you want it by city? Or like, as you're saying, it's 2,000 miles I'm going to be driving, so I'm not going to get there in 1 day. Do I have to put, hey, I'm going to be in Kentucky 1 day, then in Georgia 1 day, then in North Florida 1 day, then in Central Florida another day? Is that the level of detail I have to put?
He's referring to the first time he sent me the motion, he didn't put any dates, he just put months. And I told him he had to put specific dates, so I told him to follow my instructions and put the specific dates. He doesn't have to put what day he's gonna be in each state, but we need to know where he's going,
Yeah.
the date he's leaving and the date he's staying.
Right. Does that
Well, I'm
make
just hearing
sense?
two different things, you know. You're telling me you have to put more details here and there were no
Well, wait a
instructions in the
second, slow
motion
down. Come
form.
on, nobody's trying to argue with you here, okay?
Right.
But you're saying you want to go for 60 days and you didn't even know where you were going. Maybe California, maybe Florida, probably Florida. I don't know what to tell you. Are you going to be gone for 2 months? Can you hear me?
Yeah, I can hear you.
Are you going to be gone for 2 months?
Yeah.
And you're going to be between Michigan and in Florida? Is that true?
Between Michigan and Florida. Just
I don't
Florida.
know where you're going. I mean, you said I'm going to stay in Kentucky. No, I don't need you to tell me I'm getting to Lexington, Kentucky at 4 o'clock on December 15th. And then I'm going to be in Covington, Kentucky for an hour on the 15th or 16th. I don't need you to tell me that. I need to know where you're going and how long you're going to be gone. It's pretty simple. I've had thousands of these in my 31 years. I don't think I've ever had somebody come in and just say, I want to leave between December 15th and February 15th. I'll work with you. I'm not trying to give you a hard time. Just tell me where you're going to be and we'll go from there. Are you going to be gone for 2 months?
Mhm. Well, that I don't intend to stay in just one spot in Florida. It's probably going to be 3 or 4.
That's okay. If you tell me I'm going to be in Florida between December 15th and February 15th, I can deal with that. We'll let you zoom in for your probation appointments. I'm not
Okay. Okay. Can you put that there that it's just Florida?
sure.
Okay.
You're going to drive, right?
Yeah.
Okay. He's not on any testing. This had nothing to do with that, right?
Court work program days, but they're not scheduled until March because of this, but he did complete his class and he did make a big payment yesterday, I believe.
You granted permission to leave the state to go to Florida between December 15th of 25 and 2/15 of 26. Do you want to set dates now when he's to report by Zoom?
He already should have a date for me. We're
Mhm.
scheduled to meet again December 5th, so I'll see him before he leaves and we can figure out another appointment,
And I'll say defendant can report by Zoom
which he already does, so.
to probation. Yeah, no problem. Okay?
Okay.
Does that satisfy everything here? I want to make sure.
Yeah, I'm good.
Today's the 13th, right?
Yeah.
You're all set. I've signed the order. We will send you a copy of it, okay?
All right. Thank you.
Have fun. Good luck. Be
Thank you.
safe.
You
Thank you.
too. Bye.
Good morning. All right. Okay, people against Ahmed Alamoth, 25R 514-367.
Good morning to you and your staff, Your Honor. Muhammad Ali Hamoud, PA 6140, on behalf of Mr. Alamat, who is not
Good
present.
morning.
Good morning, Judge.
How are you?
Good, how are you?
Good. So you're going to plead to impeding. You're authorized to enter this plea on his behalf. The prosecutor offered this and it's acceptable to the defendant, right?
Yes, sir. I have authority
To-
and plead responsible.
To the charge of impeding on behalf of the defendant, responsible or not responsible?
Responsible, Your Honor.
I'm going to accept the plea. 160 is the total. Paid by November the 20th, okay? No
Yes.
charge. You can go right on 33court.com, all right?
Yes, Your Honor. Thank you to you and
Have
your
a
staff.
good day. Thank you. What's your name, ma'am? Popowski? Papowski? Popowski.
Oh, B. Then Victor.
Okay, sorry. Do you see that on the docket, Denise?
Yes, Judge, it is a probation violation sentence.
Yeah,
I have Mr. Haynes listed as the attorney. I'm not sure.
is he
if-
here?
I'm going to look to see if he's here. I thought Lisa had a note that said keep Haynes as the attorney, so
It
I
did
will
say
look.
that on one of those files.
yeah.
Let
So
me
let me,
see.
let me look.
Yeah, he's in 225, I think.
I just talked to him.
Oh, you did?
Here.
Good, thank you. Hi, are you ready on Popovsky? Okay, we'll talk to the other guy and then come on in. You have the Popovsky file? Okay, so when you're done with that one, we'll do both, okay? Thank you. Morning, Paul.
Well, good morning, Judge.
How are you?
I'm great, thank you. Thank you.
Well, that certainly sounds optimistic, not
It
just
does, but
good.
it's early.
Yeah, it's only 9:15, right?
I'll let you know at 9 PM how it went. I'm gonna go grab my jacket, Judge.
Okay, thank you.
Oh,
Mhm. Draft.
Plea form stipulated time. Your Honor, for the record, House Counsel, Attorney Mike Baldwin, E65417, on behalf of Ms. Stewart, yes, please state your full legal name.
Leonard Page Stewart.
Judge, today is the date and time set for the pre-trial. We proposed a plea form, stipulated plea form. She's going to plead guilty as charged to allowing them or Morrison's person offering another bill.
Is that what you want to do, ma'am?
Yes.
If you plead to that, I'm going to dismiss the suspend on motion of the prosecutor, the driving on suspended. The possible penalties here are up to 500 fines on the allowing unlicensed driver to drive, 90 days jail, costs or all those. Do you understand that? Did you sign, read, and understand the advice of rights? If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that? To the charge, allowing unlicensed driver to try, allowing unlicensed driver to drive, how do you plead?
Yes.
Were you in control on April 6th of 24?
Yes, Your Honor, this is the ex-boyfriend. She allowed him to drive the vehicle. Is that correct?
Yes.
So you allowed him to drive your vehicle when you knew he was suspended on April 6th of 24 on Vreeland or Peters and Flat Rock, true?
No, he had a permit and I wasn't aware that I needed to be 21 years old to allow somebody.
I see. All right, so he had a GDL.
Yeah, the driving permit.
Right. And what level was he?
2, I believe.
Okay. Are you on probation or parole?
No, sir.
Anybody forced you to plead guilty?
No, sir.
Why did it take you so long to get here?
Uh,
You live in Detroit?
Yeah,
Why did it take you a year and a half to get there?
I actually wasn't aware of how to get it all done.
I'm sorry, say that
That's
again?
my first time ever getting a ticket.
They gave you a ticket though, right?
Yeah, so I didn't
You were
they
at
didn't explain how. it
Parents'
worked.
Day honor before 10 days?
Yeah.
What did
I
that
think
mean?
I can read it. I don't know how it worked. I'm thinking I had to call somebody or that I would have told who to call.
You still live on Woodmont?
Yeah.
Were you living on Woodmont then? How long did you live on Woodmont?
A year and a half.
Ah, so you were living there in April and May when we sent notices there. Point is, you have to show up in 24.
I moved from Woodbine in March.
Well, you didn't change your address with the secretary, ma'am.
Not that long. I'm sorry.
We're talking about the year 24. This is 25, right? Yes? How long did you live on Woodmont in Detroit?
We're finally trained March 2024.
You didn't change your license. Did you leave a forwarding address?
Yeah, I changed it recently, not recently, but I changed it a little.
You gotta take care of your tickets. I'll accept, you're not on probation or parole, right?
No.
I'll accept your plea. I find it to be an accurate plea made voluntarily and understandingly. The plea is accepted. Is there anything else? And I'm dismissing the suspend. Anything else, counsel?
Judge, she had another matter, I think, and we adjourned this so she could take care of that. She's clear now. So she's a younger individual who's learning about taking care of her responsibilities, including court responsibilities. It was a little confusing. She's a very nice young lady. She's very considerate and personable, and she understands that she made a mistake and we're asking for funds and costs.
Anything, ma'am, you want to tell me? 100 fines, 110 costs, 75 victims' rights, $50 justice assessment, 40 in attorney fees, 375 or 90 days. You have a bond that you posted. So that will apply. Do you have the remaining balance?
Do we have the difference between the bond that was posted and the balance?
Yeah, I can't figure it out. It says bond amount is 150, PD brought over 160. Did you give him 160?
Yeah, I gave him 160 and my whole bond was like 300.
I think she had that other matter. Is that recalling that symbol?
Yes, yes.
Yeah, pay it back.
Judge, she posted 160 on this case.
Yeah, you have 160. Now, did we put that down as a 10% bond or cash bond, Amy?
Looks like a cash bond.
That's what it says on here. I said a 10%. That's fine. You pay 160 now. Do you have any more to pay today?
The 21st.
Where do you work? Okay. What are you gonna pay on the 21st?
How much do I owe?
You owe 200, after you apply the bond, you owe $215.
I will just pay.
You sure?
Yes.
Because I can give you more time if you want.
I just paid.
I'll give you until December 1, okay? You pay 160 now, balance by December 1. If you need more time, you call the court, we'll call on Zoom. On or before the due date. Things happen in life. I get it. Just don't ignore me, okay? Write that down on your refrigerator when you get home on a piece of sticky note. Judges don't like people not showing up, okay? All right, good luck. Acting like a nice kid. Jeremiah Davis. Jeremiah Mitchell Davis, 25F 243-817.
Please come on, sir. How are you?
Your name?
Jeremiah Mitchell Davis.
Raise your right hand, sir. You solemnly swear affirm and the penalties of perjury, the testimony you give in these proceedings be the whole truth, so help you God. You swear to tell the truth?
Yeah.
No, put your hand. You're fine. Relax. Take a deep breath. You're smiling, right?
Yeah.
Did I go too fast?
Yeah, you're good, actually. I heard you talked a little quick. I was like, I don't know how to.
Okay.
But
You understand you have to tell the truth.
I do.
Since you were in court on May 29, have you been arrested?
no,
Any new charges?
yeah, actually, I've done great. I got a house now.
No, wait a minute. I said,
Oh,
any new charges?
no charges. No charges. No charges.
You got a house now? You've done great since May?
Yes, sir.
Where's your house?
Westland.
You bought one?
Where's it?
That's all right. Renting houses is expensive.
It is such a Westland.
Makes me want to pitch a tent and by the Franklin Poet Drain, John. Rent one, huh?
I agree.
All right, get out of here. Your case is dismissed. Motion to prosecutor. Good luck to you. Wish you well. Thank you. All right, people against. I'm going to need in here Emily and Popovsky. People against Gabriel Christine Popovsky, 25W83818A.
Your Honor, good morning, everyone. Haynes back from this.
Good morning to you, Mr. Haynes. How are you today? Better than nothing. On October 27th, I entered a not guilty plea as to count 3, right? She's not guilty plea entered as to count 3. She pled to failure to submit to chemical testing on October 14th. And count 1, failure to attend the court work program, was dismissed. Your name, ma'am?
Gabrielle Kowalski.
All right, let me just check something here. So then I set a sentence date. And probation was to add another count. Do you have a probation
Just,
violation?
I think what that had to do with, there's a pending case with the blood draw, but it hasn't been charged.
Yeah, failure to refrain from consuming alcohol.
Didn't know yet because that case is still pending and that result is still pending. So that's why we held that one over, but we were for sentencing to the other two.
But I did say for her to amend probation violation to include failure to refrain from consuming alcohol. Your name? And you did that, right?
I didn't amend it, we already arranged her, I did a separate one.
That's what I mean.
Yeah.
You added another one.
Yep.
You added another one on October the 27th. Do we have a probation violation? I understand it. So I'm gonna rein her on that.
Judge, I guess we would never not guilty plea on that at this point because.
I understand. If the charge here was,
I'm sorry, I don't see him here.
I'm sorry,
I said, I'm sorry, I don't see him here.
don't worry about it. Let me see, maybe I got one over here somewhere.
Get some more.
No problem. Amy, could you please, I just can't.
What do you need? The probation ROA?
Yes, probation violation. Oh, here's one. Here's one. I can use this one. Just give me 1 second, please. Let's see something. Mr. Haynes, let me tell you what my thought process was, and then I think you'll understand. I agree with you. If we were trying to proceed with a violation of probation on the basis that she was convicted of a crime, I'm with you. But nobody's charging her right now with being convicted of a crime. We're just charging her with failure to refrain from consuming alcohol, at least probation.
But that is, if I'm understanding right, that's based on the new offense, is that right?
That's true, but you can drink alcohol 1 sip and you're not violating a criminal law. But she is violating probation by taking 1 sip.
So it's confirmed that because that there is a positive alcohol test, I wouldn't want to keep her to a guilty plea.
You don't have to. You don't have to. I can take a testimony from the probation officer.
Well, the blood draw is pending.
They don't have to.
We don't have it yet?
I just looked and there's no charges yet.
Oh, there's no charges at all?
Well, I have a police report, there's nothing on the court website, I just did the case here.
Where did this case occur at?
If you're in town.
All right. So I'll enter a not guilty plea for her on there. We'll set the October 27 show cause a month out. So we're gonna try to set this for mid-December. Amy, if you have a date when Mr. Haynes is here in mid-December. And then we're gonna sentence her. I'm going to sentence her on the initial probation violation.
Judge, have your probation by your docket December 8th.
Let's do that. At 8:30, Lisa, or Amy, is that cool?
That's cool, Judge.
Good. We're all cool with that. Okay, good. All right, December 8th. Now I have to censor on the initial violation that she pled on. And that was fair to submit to chemical testing October 14th. So you would move to dismiss the failure to attend the court work program. I entered a not guilty plea on this as to count 3. And I'm not sure what count 3 was other than the failure to refrain from violating a law, right? So it really wasn't count 3, it was actually set forth as another count 1.
Because it's not.
Correct. So, I'll just sentence her on the failure to submit. And we'll go from there. I'll listen to you. Okay, sir, do you know his name? John?
Mr. Taggy.
Mr. Tackett, why don't you go out in the hallway? We'll call you when your case is ready, okay? Thank you. All right. Do you want to say anything on her behalf?
I do, Judge, because some things have happened since we were last here on the 27th. My client, I think you ordered her to get a portable stocking device, and she did that day. I was at a time of 115 hours. She's been going 5 times a day since then, and to my knowledge, all the results have been negative. She also got a referral from her primary care doctor to an addiction specialist, and he has prescribed her on 2 new medications. I think one of those medications that makes it uncomfortable for a person to ingest alcohol, and then another was an antidepressant. So based on those 2 things, Your Honor, her compliance since then, we would ask the court to certainly not give her a jail sentence, possibly to add a day of work program or something of that nature.
Crash in September 24th incident too. Does she work?
I manage an Airbnb,
How old are you?
34.
I mean, I don't want you to say anything about that other case. This is not good, though. This is not good at all. Not good at all. I mean, I'm telling you, I don't want you to say anything on, it's going to incriminate you on the other case, but to say that this is bad would be a gross understatement. What do you think?
I mean, I know it's difficult because she hasn't technically, been convicted. I guess my concern is that it's looking like there are some substance abuse issues that maybe weren't so clear when she was
Correct.
initially sentenced. She has been testing weekly on top of the Soberling, and she's been going, and those are negative. And Gerwit's correct that her testing with the Soberling has been good. My thought process is maybe amending the class to getting her into an actual outpatient program.
I'm in that too.
Where,
SUDs in Westland.
okay, I mean, I would like to switch you to one of our agencies if that's okay, but if we get her into an actual outpatient program.
I think we need more than outpatient, frankly.
Well, we can leave it to the guidance center or Hagera, to see if she qualifies for IOP. I think they have to have 3 drinking events in 30 days, so qualifications.
Anything else, Mr. Haynes?
Go ahead.
I mean, if that case was pending and there was a conviction, I would want to put her in our sobriety court in this case. I know.
Get it.
I know. So here's what I'm doing. You'd pay additional cost of $100. You're to remain on the sober link. You're to serve 1 day on the court work program and pay $35 for that. She's testing weekly, right? So you remain on the sober link and test weekly. You're to attend outpatient treatment and or IOP as determined by the therapist following an evaluation. So you owe 135, you're gonna go to treatment, IOP or outpatient is determined by your therapist. And you're gonna serve a day on the court work program, test once a week, remain on the sober link, and I'm adjourning. I am adjourning, just be clear.
Putting an end date on those, are those considered a condition of bond and will,
No, those are the sentence on the charge for which he pled guilty back on October 27th to failure to submit to the chemical testing on October the 14th. So I'm going to go ahead and sentence her on that. Let me just make a note here. When we get multiple violations, it just gets a little bit more multiple show causes going. Sentence on October. The other violation was October 17th. So that was a sentence on the October 17th, 2025 show cause. And I'm going to enter a not guilty plea on the October 27 show cause. And we're going to set that one for here. On December 8th.
how long do you want her to have the sober link?
We're going to talk about that as we go on. I don't want to commit to that depending on what happens on the other case. So until further notice, you're to be on the sober link. Okay, give me 1 second. This is 10/27/25 show cause. So those are the orders as a result of this violation on October 14th. Entering a not guilty plea on the October 27th violation, and we're going to set that one for hearing December 8th. I'm not sure you're going to have the blood draw back. You know what? Maybe we want to go into January on that, Amy. When do you have a date in early January? Let's go to January on that. I'm sorry.
Your lock docket, January 6th is the first day.
That's perfect. Let's do January 6th at 8:30 in the morning. Sorry, Amy. So again, to be clear, the October 17th show cause, I sentenced her on. That's what I just did. Entering a not guilty plea on the October 27th show cause. We're setting that one for hearing the October 27, 25 show cause for January the 6th at 8:30. You owe $135 as a result of the sentence on the October 17 show cause. Can you pay all of that now?
Yeah.
All right, so you pay that now. We'll set you up on the court work program. Is there anything else I've missed and need to cover? All right, let's go. Gonna get your life in order, okay? Good luck. Thanks. Bodenshat. Sean Michael Bodenschatz, 20R511-802 A and B. Mr. Bodenschatz, we already had a little bit of a conversation. He hadn't been here in 5 years.
Everyone has got Sean Bowden.
But he is in a sobriety court, which is good news. Your name?
Sean Bodenschatz.
We have an R and O and a disorderly. How's he going to proceed for purposes of
We
arraignment?
wait for Darren.
Entering a not guilty plea. Was this up? No, this was up for arraignment and pretrial. Did you pre-try this yet?
I did.
I don't see a stip form.
At this point, there's no resolution. We're just gonna seek 3 trials in.
Okay. Let me just check one thing. No, I asked these guys to put remarks on citations. I've been asking them since I was 37. You know that? I don't know what happened. Resisting, obstructing officer and disorderly person. Was he drunk? Was he not drunk? Was he drinking? Not drinking? What was he doing? I have no clue. Bonds continue to $200. Since you're in a sobriety court, I'm gonna go ahead and order it. No alcohol, no illegal drugs, no marijuana. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We'll give you a new pretrial date. If you need a court-appointed lawyer going forward, we're gonna have to have them fill out a petition for a court-appointed lawyer. Where do you work at, sir?
Okay, Fusion and Sterling Heights,
How much you make there?
$30 an hour.
And barring something unforeseen, I'm not gonna appoint you a lawyer. You're making at least $60,000, right?
Yeah, I'm gonna work on a lawyer, but can I get a little extra time on that pre-trial? I have other things I'm taking care of. My mom does live with me. I've been financially responsible for her the past 6 years.
Yeah, but I tell you what, I'm gonna do this for you. Okay? I'll give you 4 weeks instead of 2. But next time you think about not showing up for 5 years, and if you see my name on the docket, don't come ask me. You got it?
Listen,
Okay, good. Then we'll understand one another going forward. Right?
yeah,
Give me 4 weeks out, Lisa. Amy, geez.
December 11th at 8:30.
December 11th at 8:30. Okay?
thank you.
You're gonna show up, right?
Yes, sir.
Unlike the last 5 years. Bonds are continued, $200. Good luck to you. We'll see you back here. Go down the hall, get your notice. If you do want to fill out a petition, you can, but I am very likely to grant that to somebody who's making that kind of money, okay? Good luck to you. Michael Charles Welsh. 25T645571.
What's happening?
Do I have Officer McLeod here? Oh, wait a minute. Your name?
Michael Welch.
Do I have Officer McLeod here? But it's not time for this yet, so it's scheduled for 9:45. Is he out there, Amy?
I met with the prosecutor at the side.
Who's the department rep?
Anthony Bologna. He dismissed it and I signed it. And he said, come to courtroom.
Let me look around to see.
It was scheduled for an informal.
Okay. Yeah, what happened? Then did I schedule it for? It was scheduled for an informal on the 6th.
It was rescheduled. I had a witness. We had a medical procedure that couldn't.
That's fine. You just shouldn't have gone to the prosecutor.
That's what they told me to do when I came in here.
Well, I'm sorry. I'm just telling you, there was a mistake made because lawyers cannot be involved in informal hearings. Did we notify the office?
I didn't have a lawyer.
Prosecutor's a lawyer.
Oh,
He can't be involved in an informal. The defense lawyers cannot be involved in informals. So you were given wrong information. The question I'm having is Officer McLeod here? I see it was scheduled for 9:30 today. Is he here, Lisa?
He is not here yet.
Jeez. All right, look, I'm gonna give him 2 minutes. Have a seat. I'll be right back with you. If he's not here in a couple minutes, I'm gonna recall it. The case is going to be dismissed either way. But I see what the prosecutor wrote down. I see what happened here, so I'll go through that with you again. Kristen Marie Sigler, 25R514324. Your name?
Kristen Sigler, KRISTYNSIGLER.
Thank you for the spelling.
You're welcome.
All right. So you met with the department rep, right?
Yes, sir.
And you are going to plead to impeding traffic, right? All right, to that charge, responsible or not responsible? Hang on 1 second. All right, I'm gonna accept your plea. I'm going to dismiss the speeding. Fines costs are $170. You can go down the hall and take care of that. And you're all set, okay? Have a good day. Thank you. Okay, so now we're gonna have to go get Mr. Tepe, John. I would appreciate that. Thank you. All right, Mr. Tackett, people against Chase Tackett. 25R514318 A and B. We got a slew of kids here, eh?
Yeah.
Your name?
Chase. Chase Hammond.
So you're gonna plead to impeding, they're gonna dismiss the expired plate and speeding, right?
Yes, sir.
To that charge of impeding, responsible or not responsible?
Responsible.
Plea is accepted, speeds dismissed, expired plates dismissed. 185 is your total. You can go down the hall and take care of that, and you're all set. Good luck. Jones. People against, Caleb Jones. 25R514374. How you doing, Mr. Jones?
I'm doing well, Your Honor.
Your name?
Bill Jones.
You're gonna slow down, right?
Yes, Your Honor.
Where are you, a senior?
I'm a student athlete at Middleton University. I play baseball.
Yeah?
I was on my way.
Well, how are you gonna play baseball if your face is bashed in, huh? Because you're driving too fast. What position you play?
Shortstop driver.
They got other shortstops there, right?
Yes, Your Honor.
I'm just kidding. Slow down though, okay? Good luck to you. You studying hard?
Yes, I am. Yes, Your Honor.
What's your grade? Are you a freshman?
I am a freshman. Okay.
What's your grades?
I have all A's as far as.
All A's?
It's more difficult in the future.
What's that?
Could be more difficult in the future.
How many credits?
I'm taking 12 credits right now.
Well, why only 12? Are you working full time?
No, it's just, we have 30 hours for practice.
I get it. I'm just kidding. I played college tennis. I get it.
Really?
To the charge of, what's that? Central, Michigan. Way back. Your parents weren't even probably met by then. I mean, we're going back, way back.
How far back?
To the latter part of the 70s.
They won last night.
Yeah, I know they did. I watched it. And they beat them pretty bad too, Buffalo. All right. Impeding traffic, responsible or not responsible? Slow down though, please. Speed dismissed 150. Good luck. Maybe I'll see you in the pros someday. You know, I had a couple guys in here that ended up in the pros. You never know. Yeah. I mean, I don't want to say anybody's name because I shouldn't be saying that, but I remember one guy telling me he lives in Michigan. He says, I'm going to go pro in baseball. Oh, sure you are. He ended up doing very, 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 very well. In fact, made the all-star team. Good. Good luck. Have a good day. Thanks for coming, Dad. Appreciate it. Maya Nicole Bailey. Oh, and bring in Mr. Officer McLeod's not there, right? Ms. Bailey, why don't you have a seat at the table there? Officer McLeod's not here, right, Lisa?
No, he's
mean,
not here.
Amy,
No.
come on up here, Mr. Welsh. Michael Charles Welsh. I keep calling you Lisa. I'm sorry. It's just habit. 25T645571. All right, Mr. Welsh. Your name?
Michael Charles Wells,
What do you do for a living?
retired chemist.
Yeah, I mean, most people don't dress up like that.
Well, it's been a while. Showing some respect.
Well, I appreciate it. It's very nice of you.
I still fit.
That's, you look in great shape. The officer failed to appear, case dismissed. I just want to read what the prosecutor, because I can't take that into account really, but it's good that it got dismissed. It says lane closure was not clear based on photos. Where did this happen at? West and William R. It was just a mess around here with traffic. All right, good enough. Case dismissed. Good luck to you. Have a great day. Thanks.
Some kind of letter or piece of paper that says it's been dismissed.
We can give you a copy of the register if you want.
I don't want to create work for people.
I'm sorry, Amy, have somebody print this off for him, will you please?
Yep, just have him come to the window.
Yeah, you go down there, they'll give you a copy. Have a good day. Kira Graziano Caravallo. 25R514364. Your name, ma'am?
Eric
You want an informal hearing, right? All right, give me a date if you would. This is Rockwood Officer Ball.
Let's do December 11th
You good with that, ma'am?
at 9:30. Oh, he's got another, how about 9 o'clock?
At 9 o'clock, December 11th at 9 AM. You can go down the hall. We'll give you your notice. Any questions?
Thank you.
Good luck. Helen Hancock, 25R514377. This is going to be another informal hearing that we're scheduling. And this is with Officer Boss, so we might as well do both at the same time. Your name, ma'am? You want an informal? You got a clean record. Did they offer you anything? They didn't offer you impeding traffic?
We just like an informal hearing.
Call him, Mercure, will you? Do you want impeding traffic?
I was just told the informal hearing would be the better option. It's my first time, so I don't know a whole lot.
You sound with time here.
Miss Bailey, I'll be right with you, okay?
You still want me to sit here?
Pardon?
You want me to still sit here or go back there?
You're fine right there, okay? How old are you? You work?
I do.
Where you work?
Hospital in Western.
What do you do there? Okay. Lieutenant, how you doing today?
Good, guys. How you doing?
You in a good mood?
Oh, yes. How about you?
Always. Your name?
Yes. Detective Lieutenant Steve Ricker, Rapid Police.
You're not gonna offer impeding?
On the per officer Bob's request to set up for an informal hearing.
Nobody's gonna play games in here, right?
He called me last night and just set the two up and, the lady for informal hearing also.
Nobody's playing games, though.
The officer just said he needs to schedule for an informal, that's.
I mean, I don't even see the point in making her come back unless he's not gonna show up, and if he's doing that, that's not right. I don't see the point in making her come back, and I'm certainly gonna be disappointed if he comes in here and tells me, Judge, I don't want to give her impeding because she's got a completely clean record, and since we give it to everybody else, that's just not fair. I'll set it for the other hearing date if that's, but if you tell me you want impeding right now, I'm gonna tell him to go give you impeding. And if he won't do it, I'm gonna do it on my own motion. It's up to you. But I mean, seriously, this stuff about, how do I say this? Why is an officer saying to set it for an informal unless somebody's doing something that I'm not gonna like and not approve of? You sure can. It doesn't go on your record, it's 0 points.
Biggest hope was just to not have.
Yeah, I know. That's why I'm calling them in. I don't want you to have points either. And I don't want people writing tickets and then saying I'm gonna set them for informal for whatever reason. I just don't like it. You know what I'm saying?
Oh, yeah.
Are you still willing to give her impeding if I ask you to do that?
It's fine with me.
Or do you want to come back and hope that he doesn't show us?
So like I said, my hope was just not points, so if that's.
No, I know. You seem like a very nice kid. That's why I called him in, because the other one, I had a thicker record. I didn't know. It didn't keep me in there.
Yes, sir.
And since you're going through all of this, seemed like a very nice young lady. Yeah, we're gonna. All right, you want to plead to impede? And you're offering.
Yes, sir. Thank you.
Please, to the charge impeding, responsible or not responsible. Please accept at 150, and you go down the hall and take care of that, okay? Speed's dismissed. Good luck, young lady. Thank you, Lieutenant. Maya Nicole Bailey. 25G306372B. How you doing?
Good.
Your name? Charges failure to pay fines and costs is ordered. If you want a lawyer, I'll give you one. You want a lawyer? You sure?
Yeah.
You don't want one? Okay. The charge is failure to pay fines and costs of $545. That is the charge. That's a technical violation. I don't want to scare you if you plead guilty or if you're found guilty. I'm just have to tell you that the possible penalties are up to 5 days jail. Do you understand that?
Yeah.
Did you sign the advice of rights?
Oh, yeah.
Did you read it and understand it?
Yeah.
You plead guilty. You'll be giving up all those rights, and we're not going to have a trial. Do you understand that? You have the right to a lawyer. If you want one, I'll give you one. You want a lawyer. To the charge, you failed to pay $545. How do you plead?
Yes.
Did you fail to pay your fines and costs as ordered?
Yeah.
Anybody force you to plead guilty?
No.
I told you to pay $25 a week starting August 8th, right? I also told you if you didn't have the money to come talk to me, right?
Yeah.
You never came and talked. You never paid anything. You never bothered to call and say, let me speak to the judge. My engine blew up. I'm getting evicted. My heater went out. My air conditioner went, whatever the case. Why didn't you do this?
I was a single mom, so it's really hard to
You know how to use Zoom?
Huh?
Do you know how to use Zoom?
No, not really. I do Zoom for
Where do you live?
probation.
Where do you live?
I live in Brownstown.
You gotta stop this.
I know.
Okay. I mean, the most perplexing thing to me is that I offer this and then people don't take advantage of it. It's like, I bet there's not a judge in this Midwest that goes on every case and says, if you don't have the money, come talk to me. I'll give you an extension. I don't care how many times we have to do it. Maybe they are. Maybe they're all doing it. I don't know. I don't care. But I do it and people don't take advantage of it. And now you're coming in here and you're going to tell me I didn't have the money. And I'm going to say to you, well, what I just said, why didn't you call? Why don't you come in? Did you do your anger management program?
No, I was gonna pay.
Did you do your community service?
Yes.
How come you're taking so long to do everything?
Well, it's just the money situation.
Are you married?
No, I live paycheck to
Yeah,
paycheck.
I'm sorry, you did say single mother. How many kids you got?
I don't even want.
Is the father contributing?
He just started to come back around.
What do you mean?
Like, he wasn't around during her like birth or anything.
How long she been, how old is she?
She's a year and a half, 19 months. And he just came back.
What do you want from me? Tell me what you want me to do.
Well, I already plan on paying it, not this Friday, but next Friday.
All of it?
Yeah. I should get a really big paycheck then, because I just got another job, so.
Where?
FedEx.
Can you get me a job where I can have that kind of money? Huh?
Well, I'm taking like the whole paycheck and I'm just.
I don't need it all now. But you gotta get your anger management done. I got you on probation for 6 months. We have a review hearing date, January 22nd. What do you want to do? You want me to give you more time, or else I can just say, keep you on probation and you pay it all by?
A little more time, I would appreciate it.
You pay $200 by December 1.
Okay,
Balance by January 5th.
okay,
Okay?
Yeah.
I won't assess costs. I'll keep you on probation. If you need more time, what are you gonna do? Well, I'm not gonna get on the phone with you. You're gonna call the court. You're gonna say, I'm gonna talk on Zoom to the judge. Figure out how to use Zoom. If you can't do that, then come in here on or before any due date, or go on Zoom with me on or before any due date at 8:30 in the morning. Okay?
Yep.
You got it?
Yep.
You're gonna get in anger management.
Yes.
Good luck.
Can I say one more thing?
Yeah,
I saw you on TikTok.
yeah.
Yeah. It's like, oh my God, no.
Don't remind me. Good luck. Charmaine Suzanne Summers, 25F245. Who's your lawyer, ma'am? Who's your lawyer? Yeah,
Baldwin.
call in Mr. Baldwin, please. Tell him I'm ready. Just wait 1 second. Don't you, just give me a second, okay?
He tried to be getting Baldwin. Or tried to be John Summers.
How you doing today, Ms. Summers?
Yes.
There's a lot coming at you. Welcome to life. Yeah, I know. It's like being in outer space and watching meteors coming at us, isn't it? But you're smiling.
I just stopped living in my car for 2 years straight, because I was waiting for a senior place to move in.
Let me call the case and we'll talk. People against Charmaine Suzanne Summers, 25F245 003. Your name, Mr. Baldwin?
Attorney Mike Baldwin, P 65417, on behalf of Summers, Miss King, this big stage Baldwin.
Charmaine Suzanne Summers.
Reckless driving, she stands mute, waives formal ratings.
Yes,
You work this out, she's pleading the care of us.
yes.
What did she do?
Judge, first of all, she, 7 years old, she got a little disoriented.
She doesn't seem 70 years old.
She's sharp. She was a food delivery person. The way that the road system was set up, it appeared part of it was, closed and part of it was still open.
Okay.
She was on the open side and then realized she had put herself into a precarious situation. She was disoriented, confused, and it was unintentional. And the police officer.
She drove around the road closed sign and barricade, drove over half the wrong way on a one-way. You gotta be careful, okay?
Yes.
To the charge careless, do you plead responsible or not responsible? That's 3 points. Do you understand that? Yes? And the reckless will be dismissed.
Yes.
I'll accept the plea to careless, dismiss the reckless. Are you living in a home now?
Yeah, my son bought a home.
I'm sorry?
My son bought a house and so I could live there.
All right. You were living in your car for 2 years?
Yeah, but I wasn't supposed to tell anybody.
Pardon?
I wasn't supposed to say, oh, you're not supposed to do that. Yeah.
Do you work?
Well, she does. She's a food delivery person.
Now, no cash.
That's what she was doing.
All right.
And she was following her GPS.
Okay. I'll cut it down for you a little bit. Let me see something here. Let me just check one thing. All right, she's got a perfect record. I'll tell you what, 170, okay? Can you pay that or you need time?
I get my check on Wednesday.
Can you pay it all then?
Yes, I will.
So I'm gonna give you until next Friday. Is that okay? That's November 21. Right? Yes. You pay by next Friday.
Yes.
170. Good luck. I really wish you well. Thank you.
You're welcome.
Rachel Butts. 25R514310. Come on.
For the record, Your Honor, House Counsel within my call on behalf of this, but next thing you just please visit the whole legal bank.
Rachel Oda.
Judge, today's date time set for an arraignment pre-trial and an open house party for purposes of arraignment. My client stands mute, waits total living with the general information.
Okay, I'll enter a not guilty plea. Then what happened? You got her a good deal.
I did, I got it.
She's gonna plead under that and 6 months, right?
Yes, Judge.
Is that what you want to do? All these ordinances are different, but I believe that this one calls for up to 500 fines, 90 days jail, costs for all those. Do you understand that, ma'am? Yeah, you understand that?
Yes.
And you're not going to jail, but we're gonna have a conversation. Did you sign the advance of rights? You look scared to death. Why are you scared?
Things got out of control.
I know,
They got out of,
I know.
and she's taking responsibility.
I get it. I get it. Just relax. You understand everything I'm saying?
Yes.
If you do it, just, you look like you're gonna cry. I don't want you to cry. Pardon?
I'm not.
Good, good. Okay. If you plead guilty, you're gonna be giving up all those rights. I'll place you on probation, set terms and conditions, and if you're compliant, the case will be dismissed in 6 months. Do you understand that? You understand all your rights?
Yeah.
To the charge open house party, how do you plead?
Guilty.
Do you live at 22553 Candace in the city of Rockwood, County of Wayne?
Yes.
Were you living there on October 31?
Yeah.
And you live with your mom, dad, what?
It's my dad's home, but he comes part-time from the Keys, Florida Keys, back and forth between Rockwood and there.
Does your mom live there?
No, my parents have been separated since I was 4.
So you're pretty much living there by yourself?
My older brother, who's 23, lives there with me.
Did you have an open house party?
Yes.
How old are you?
19.
And you had a bunch of kids there drinking? 50 plus high school kids.
It got out of hand. I didn't mean for all of them to come, but
How many do you mean for them to come?
I only invited about 9 or 10, but everything.
They invited 3 or 4.
Yes, exponents. Plus the alcohol came in after,
You can't do that.
yeah.
You know what would happen when one of those kids get drunk, drive out of there and kill somebody?
It was my goal to have a huge house party.
Well, I didn't say it was your goal, and I didn't say it was your goal to have anybody hurt, but you gotta be careful.
I understand.
Are you on probation or parole?
No.
You were completely in control of the house though, right? At that time,
Yes, I was the one in charge of it.
and you invited them there, 9 or 10 of them, who in turn took it upon themselves to invite other people to your house. Were you drinking?
No.
You didn't drink?
No.
What were you doing?
I was hanging out, making sure that nobody was messing up my stuff. And I did call my brother and my sister to come back for help. But my brother was at the bar with his friends on Halloween and my sister was 40 minutes away. I didn't need to call the police on my home party, which I probably should have done. But
All right, good. Are you on probation or parole?
no,
Anybody forced you to plead guilty?
no.
You ever been in trouble? Do you work?
Yes.
Where?
Full-time job at Dollar Tree and I'm a full-time college student at
Where?
Henry Ford College.
Yeah, you don't want this kind of nonsense on your record, right? How hard do I have to be to make sure that you don't do this again?
You only get to learn my lesson.
You have a probation order down there.
I believe I have one of those.
I'll take your plea. We'll take it under HIDA. Just take a deep breath for a second. Well, you're making me nervous up here, huh? She's making me nervous, Mr. Ball.
She really feels that she's taken the world on her shoulders, being a younger individual. This is part of being an adult, is to make the right decisions that ensure that other people aren't put in harm's way.
Yeah. Be a leader, not a follower. Right? What are you studying at Henry Ford?
Business administration,
Yeah, so you're gonna have people working for you probably. You're gonna be running
hopefully.
Chrysler Corporation or whatever. What's it called? You get my drift. I mean, you understand there could have been severe consequences to it, right?
Yes.
Anything you want to say? I'm gonna censor.
No, she's a very bright individual. She had already figured it out. When I was talking to her, she already had the right answers.
Where'd you go, Carlson? What was your grade point?
Not very good.
Why not?
My parents, well, my brother and my father got in an car accident in my sophomore year of high school. And I kind of became a little depressed and stopped really doing stuff my sophomore year, but my junior and senior year, I began to pick it back up, but my GPA was still low from my earlier years. But in middle school, I had a 4.0.
What do you have now? What's your grades right now? If I called over there and said, tell me what grades Ms. Butts has midway through the first semester. This is your first semester, right?
Well, it's my second semester, but my first semester, I only took
two classes. But that was over the summer. And I have mostly Bs, I might have a C.
You don't want to give Cs. You seem like a nice kid. 6 months probation. You cannot leave the state without the consent of the court or violate a law. If you change your address, place of employment, or home telephone number, you must notify probation. You have to report as directed. I've gotten too soft. I would have been a lot harder on this 20 years ago. You know that? 2 days.
I know that, Judge.
2
I
days.
was here with you.
2 days of community service. You complete that by January the 5th, okay? 50 fines, 50 costs, 75 victim's rights fee, $50 justice assessment, 120 in probation fees, 345. This is such a break. I'm gonna give you a review hearing date. You just seem like such a nice kid. I can tell you're remorseful, but you gotta think. You have to think, right? You wouldn't expect if you're having a party. Now, listen, I was 19 once. I was no angel either. I'm just telling you, when you're having a party, you know people are coming over there to drink, right? Right?
Yeah.
Don't put yourself in that position. Give me a review hearing date, Amy, and then we're gonna talk about time to pay. How about if I just had you pay 50 a week?
She can pay,
I want to pay it all as soon as possible, preferably today.
Okay, if you want to pay today, that's fine.
if one of those considerations under that she'd like to set.
I get it. I'm gonna take it under HIDA. So I need a review hearing date like late April.
Yeah, sounds good.
April
That sounds good.
28th at 8:30.
April 28th at 8:30.
Perfect.
Study hard.
Yes.
You know, we all have a few things that we go back and you don't want to regret things. Study hard. I should have studied harder when I was in college, to be honest with you. I mean, I did well, but I could have done better. Good luck. Wish you well. Have a good day.
Thank you.
Go down, get your review hearing date and go over to probation. Thank you.
When is her payment due?
She's paying now. I'm sorry.
Pay today?
Yep. Good luck. Who's this with you?
My sister, Amanda.
All right, keep her on the straight and narrow, Amanda. How old are you?
I'm 24.
All right, so you're 5 years older. Keep her on the straight and narrow. That's what we do for younger siblings. Have a good day. Good luck, kid. Stay seated, everybody.
Judge.
I get yelled at me, are you? Brownstown, yeah. A search, handful of search warrants. So whatever, how many people, sure.
In this honorable court hearing these matters, if any conflict were to arise, we'd waive such conflict so that this honorable court could hear these matters.
Thank you, sir. This court also does not believe there's conflict either to Michigan court rules or the cases decided thereunder. To the extent there is a conflict, that a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case, people of the state of Michigan versus Omar Smith. Morning.
And good morning, Your Honor. Joseph Hall, appearing for and on behalf of Mr. Smith, as well as.
Good morning, Your Honor. Michael Litz, on behalf of. Why do I get both of you?
Jan and man.
I'm sorry.
Just a lucky day, Judge.
Yeah.
Just a lucky day.
To start out. All right.
Your Honor.
Is Mr. Smith here?
Yes, sir.
Mr. Smith, could you state your name for the record, please?
Omar Smith.
Thank you, sir. All right, what are we doing?
Your Honor, we've spoken with counsel. As you know, the nature of this case, there's an extensive amount of discovery that's outstanding. We have communications on that. I know he's doing his best to facilitate the same. We would ask for an additional adjournment of the PCC date to accommodate that discovery process.
Okay, so there's more discovery to come that hasn't been obtained and.
Exactly. Yeah.
We just got the autopsy report here. The slugs that were pulled out of the car still at the MSP back in Northville. When they're done there, they have to go to Detroit for ballistics. So there's the investigations.
Okay. How much more time are we looking at?
I would say at least 4 weeks.
I agree.
Mr. Vincent, do you want to, you don't care. All right.
I'm just happy to be.
Never mind. Is 13th, why don't I adjourn it out to December 18th? See,
That date works with our calendar, Your Honor. Thank you so much.
Thank you. December 18th, 2025, 9 a.m. Bond continue. Well, thank you, Mr. Smith.
Welcome. Thank you, sir.
Court calls case People versus Lloyd Sanders. Good morning.
Good morning, Your Honor. Gemma Dadish on behalf of Mr. Sanders. Mr. Sanders, can you please state your name for the record?
Lloyd Sanders. Thank you.
Your Honor, there is an offer on the record. Wayne County's entire Zoom was filled up this week. I'm gonna have to adjourn to be able to discuss that with him and get the plea form ready before his next court date.
The 4th, or you want the 11th?
The 4th should be good, Your Honor.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
I'll talk to you tomorrow, Mr. Sanders.
Court calls case People versus Edward Byrne.
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
Oh, there you are. Okay, good morning.
Good morning.
Byrne?
Yes, Stephanie Cannon on behalf of Mr. Byrne, and he should be appearing by Zoom, Your Honor.
Byrne, can you state your name? You have it.
I think there's a person who makes it.
I'm here, Your Honor.
All right, state your
Good
name,
morning.
please. Good morning.
Edward Stewart Byrne.
All right, thank you.
And Your Honor, we're going to ask for just one more adjournment in this particular matter. He just recently received actual paperwork from the front of the court stating he may have be overpaying. And I want to take a look at that before we potentially waive it up to circuit.
He overpaid or is
They're
overpaying?
going to relook at it because his W-2 makes substantially less, and he has been making substantially less since the order was entered. So they're trying to figure out what went wrong. At least that's what it looks like based on the paperwork I received. I want to just be able to review it and see what's actually happening in the front of the court case.
All right. Madam Attorney General, you know anything about that or?
Not, Your Honor, but I have no objection.
All right. Want the 4th or the 11th?
Your Honor, the 11th would work better. But like I said, once that's done,
Would.
we'll likely just be waiving the very next day.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, sir.
Call case People versus Terrence Ginyard.
Good morning, Your Honor. Assistant Attorney General Carissa Williams on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard, who appears via Zoom. Your Honor, Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard. All right, you need to turn on a camera, please.
I'm trying to, Your Honor. 1 second, sir.
Apologies, Your Honor.
All right, there he is. All right, he's waving.
He is waiving, Your Honor. There was an offer made in this case, and we just need to get his bond applied to the arrears at this point. But the offer is, if you don't mind that I read that on the record, if he begins paying his ongoing support and pays the arrears down to 7,400, approximately 25% of the arrears, which he's already done, and pleads guilty as charged, the AG will ask the court to place the defendant under delayed sentence under 771. If he continues to pay his order during delay and pays the arrearage down by 50% to $5,000, the charge will be reduced to attempted felony non-support. And if he pays the arrearage in full, the charge will be reduced to disorderly person or non-support. With that understanding, Your Honor, we will be waiving the preliminary examination.
And that's a correct statement of the agreement.
Yes, Your Honor.
Yes, sir. Mr. Ginyard, you're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor, I understand.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution on this matter.
Yes, sir, I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant found over to circuit court on both counts.
Your Honor, we acknowledge receipt of information. Wait for my reading, stand mute at this time.
Pending every way formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
January 6th at 1:30 with Judge Cumke.
January 6, 2026, 1:30 before Judge Cumke.
Thank you, Your Honor.
Thank you.
Bond will continue.
Thank you, sir.
Have a good day.
You do the same. Court calls the case People versus Laron Moore.
Good morning, Your Honor. Michael Vincent on behalf of the law. Please approach it.
Your name, sir?
Ron Moore.
Thank you. You're requesting an adjournment?
Yes, Your Honor. We have numerous videos still review. At the appropriate time, I'd like to make a bond motion too.
All right. Adjourn this matter to December 11th, 2025, 9 a.m. without objection. As to bond.
Right now, his bond is 25,000 cash or surety. I'm requesting a somewhat lower bond, maybe a $15,000 cash or surety, 10%, if that is within reason.
Response from the people.
People would object, bond is set relatively low considering the nature of the offense. This is an armed robbery and a home invasion charge. The defendant does not have significant criminal history, showing some misdemeanor possession of a master key of a motor vehicle, and that a juvenile driving with a license suspended was dismissed. However, based on the nature of the offense and the danger to the community, people would object to any modification of bond.
Anything else, Mr. Vincent?
He would be tethered to his mom's house. All appropriate conditions.
I would agree that, quite frankly, that bond is set low, given the fact that the defendant is facing a capital or life offense, potential life offense. So the court believes that bond is, I'm not going to raise it, but that the bond is set appropriately and deny the request for a bond reduction. Bond will continue.
Thank you, Your Honor.
Court does call the case People versus Denicia Charles.
Good morning, Your Honor. Christina Sachs, standing in for Edward Drukes with Ms. Charles. Is that correct? Ms. Charles, please state your name for the court.
Denicia Charles.
All right, thank you.
Your Honor, we're asking for an adjournment.
Without objection, probable cause conference will be adjourned to December 11th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case People versus Charles Hudson.
And good morning, Your Honor. Christopher Coyle, the attorney on behalf of Mr. Charles Hudson. I say that because I understand there's a Christopher Coyle on the docket today as well.
Oh, I thought that was you.
No, never mind. Mr. Hudson, can you state your name for the record? Charles Hudson. Judge, we're here for the PCC, and the prosecutor and I are attempting to get perhaps some type of resolution here at the district court level before we move up to the circuit court. So we're just asking for a little bit more time and adjourn the PCC out.
The 11th, will that work for you?
Yes, Your Honor.
Probable cause conference, December 11th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case People versus Shayna Desir.
We are Saxon for Shania Desir is present to my right. Please state your name for the court. Shania Desir. I'm sorry.
Kenneth Overwater, Assistant Prosecuting Attorney.
All right.
Your Honor, we're asking for an adjournment. I have not received any discovery yet.
Okay, this is part of the new system and discovery.
Yeah.
Problem. Well, I'll ask it later. I'll just go December 11th, 2025, 9 AM on this. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Marissa Dix.
Good morning, Your Honor. Robert Elman with and on behalf of Ms. Dix.
Her name?
Good morning, Your Honor. Marissa Dix.
Thank you.
Your Honor, may we approach in this matter?
Sure, I'm not busy. Come on.
Thank you, Your Honor.
Sure. You're requesting an adjournment. Our record should reflect you had a bench conference in this case. You're requesting an adjournment. You're requesting an adjournment.
Yes, Your Honor, for purposes of PCC, yes, we're trying to work out a resolution here at this level. We need a little more time to do that.
I'll adjourn it to December 11th, 2025, 9 AM. Also, as to bond, defendant is on a bond violation. Given the nature of the charges, her bond was revoked because she was in the exclusion zone. Counsel has explained what happened. All right. And also that something the court didn't know is that she was in contact with community corrections while this whole thing was happening, which the court did not know, but that all aside. So I'm going to reinstate her previous bond with its conditions. All right, so she can be released. The other thing is that I've apprised counsel to work with the prosecutor to, she was going to take her bike to work, and it's going to be cold out there. So I think she should be able to take an Uber, see if we can draft or reset the exclusion zone so that a major thoroughfare she can take a major thoroughfare so she can get to work. And so that way she can tell the driver, yes, I can go down this road without fear that she's clipping the edge of the zone. All right.
Thank you, Your Honor.
So her bond is reinstated. I'll need an order with all the conditions. All right, she can be released.
Thank you, Your
All right,
Honor.
thank you.
Thank you, Your Honor. Thank
You're
you so
welcome.
much.
Court does call the case, People versus Desiree Gray.
And good morning again, Your Honor. Robert Elman with and on behalf of Ms. Gray, who should be here over Zoom. Ms. Gray, can you please state your name for the record?
There she is. Well, we see her finger. Oh, there she is.
Gray.
Thank you, ma'am. Go ahead. She's waving.
Yes, Your Honor, we're waiving. There should be a signed waiver in the file.
Ms. Gray, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right?
Yes, Your Honor, there was an offer extended for this waiver for long.
Yes, go ahead, please.
My understanding of the offer is that the defendant is going to waive up and plead to 2 counts of possession of cocaine less than 25 grams under 7411 in circuit court.
That's correct, Your Honor.
All right. Preliminary examination having been waived, defendant found over to circuit court on all 4 counts.
Thank you.
Mr. Elvin.
We waive a formal reading. Sorry, Your Honor. Stand mute to the charge.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all charges. Pretrial will be set for
January 7th at 1:30 with Judge Conlon.
January 7th, 2026, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Ms. Gray.
Thank you.
Court does call the cases of the people versus Joseph Griffin.
Good morning, Your Honor. James Fifelski on behalf of Mr. Griffin on the file ending in 1698.
This is the public defender Hannah Apple appearing on behalf of Mr. Griffin and the remaining three files. You're missing just
And I'm still waiting for some video recovery that the prosecutor's office is preparing, so yeah, for adjournment for that.
All right, and maybe this is the case to ask about. Do we have any idea? I realize it's not anybody's fault that it's part of the new, well, it's not part of the new system, but there's a glitch or something. Do we have any idea when that's going to be resolved for discovery purposes?
I can get a more definite answer for the court in a few minutes. But my understanding is that there are fixes underway for the public defender's office to be able to receive the discovery, and we're working through that. And I think for private counsel, it's going very well. So we are just in the process of getting it. I think a timeline is probably next week we'll have it all sorted, but I'd be happy to get a more definite answer for the court in a few minutes.
Okay, if we could, but
Yeah, for sure.
when you say it's working for private counsel, is that going to? If counsel's conflict counsel, are they grouped in with private counsel or?
Irritatingly, it depends. So.
Okay, that's
I'll
definitive.
get a
No,
more definite
that's.
It has to do with the integration between the new system and the old system. That's where the sort of difficulty is. I'll try to give the court a better answer.
I spent some time on the phone with two people from each of the offices, both of whom had no idea what they were talking about, and I understood more. So they confused me more than anything in the world. All I knew is there was a problem at the end. All right.
I will work on that.
Okay. I should have just gotten to you because I knew.
For
Okay.
the Griffin issue specifically, some of it has gone through via email already, but there may just be more coming.
Got it.
I'll try to get the court a better answer.
All right. What I will do is I will grant the adjournment. We don't just bring it back. Normally I'd go 2 weeks, but let's just do the 3 week. So I'm going to adjourn this probable cause to December 11th, 2025 at 9. And then hopefully things will be resolved. All right. Thank you, Mr.
Thank you, Your Honor. Your Honor, one more request. Would the court consider release to inpatient treatment? All of these cases, I believe, are related to substance dependence issues.
I don't have an issue with that. The public defender normally would prepare an order or a standard order. So if it's submitted on these,
I will send that to the court later today.
the only thing that has to be included in that is that if he's in custody and he's released that way, that there would need to be a tether run.
Fair enough. Thank you, Your Honor.
Thank you. Court does call the case of the people versus Langley.
This is Attorney Zulson for Ms. Lee.
Your name?
Nathan Lee.
All right, what are we doing?
Your Honor, we argue for the motion to modify the no counting order.
Okay, so first of all, what am I doing with the probable cause conference that's set for today?
Your Honor, we are going to adjourn the probable cause conference.
All right, I'll need a green sheet filled out. I don't have an issue with that. I did not receive a response. Normally this would have been set for 3 but I didn't receive a response. Do people have a position on the modification of bond?
Yes, maybe it's.
You may. Probable cause collected in this case. We've had a bench conference in this case. The motion as well as probable cause, I will adjourn now to November 20th, 2025 to accommodate counsel and everyone at 3:30. Bond will continue at this point with its conditions.
Thank you, Your Honor.
All right, thank you. Okay, you're all set. Thank you.
Your Honor.
Court calls the cases of the people versus Joseph Hodson.
Calvert on behalf of Mr. Hodson.
Public Defender Chelsea Vergils on behalf of Joseph Hodson on cases ending in 5274 and 5284. Can you state your name?
Joseph Hodson.
All right, thank you. What are we?
We're making a competency referral on these cases. I can have the order later today.
And I would ask that my case also be joined with the competency referral.
Okay. So I'll order without objection a forensic evaluation. I'll set a competency hearing in this matter for
February 12th.
February, well, is that right? February 12th, 2026, 9 a.m.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank you. Bond will continue. Thank you. Court does call the case. Court does call the case People versus Brandon Dempsey.
Good morning, Your Honor. Jay Grant Miller, P58658, on behalf of Mr. Dempsey, who stands to my right.
Your name?
Brandon Dempsey.
Thank you. This is another discovery.
Your Honor, I know my client's name and I got an email saying what his charge was. So I would like some discovery.
So you guys close, huh?
Okay. I think we're ready to go to trial.
For the record, I did just send a protective order for this case to the court as well. And I think I sent discovery back. But
got it. Okay. And so we're not sure at this point, but
space is a little tight. I can probably confirm that while I'm here for the next couple of hours, but we can get Mr. Dempsey.
And I don't have the order, but if you just send it, my staff is kind of working. I get it. All right. We'll look at that. I'll set this for December 11th. 2000.
Your Honor, just based on the nature of this case, and there might be a
So
lot.
why, when I give a date, did he look at his watch?
Because there's a date window on my watch, Your Honor. I really.
Okay, all right,
put on
all
my
right.
glasses to
Fine.
actually be able.
Fine.
to
No,
set
I
time.
don't know. You don't have to show me. I just didn't get it.
Based on the nature of the case, and I assume it's going to be some rather extensive discovery, if we could maybe go another week or two out.
Okay, I'll put it on the 18th.
That's perfect.
Because he's out of custody.
Yes, yes.
Is that okay with your watch? No, never mind.
I'm
December
checking my phone
18th,
now.
December 18th, 2025, 9 a.m. All right, I just don't want it to get too far in case there becomes an issue.
Absolutely, Your Honor. And
all right.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case People versus Robert Byrne. Your name, sir?
Robert Barr.
Where's Mr. Killawald?
He's in the hallway, Your Honor. I'll get him. Thank you.
What?
He's also,
I didn't hear you.
oh, he's also scheduled next week.
Mr. Barnes.
So he needs to be here though. Killawald, really? Oh, man.
I don't know if he's got anything else.
Sorry.
Morning, I'm Rob G. Kill on behalf of Mr. Barner.
All right. What are we doing?
Judge, I met with my client last night at the jail. We would like to have an examined.
Discovery is complete.
As far as I know.
And would the people have their witnesses available the 25th?
Some of the witnesses listed will be hard to get, Judge, but we'll do it.
Judge,
We're not probably not gonna get Joe Biden or Donald Trump or Kamala Harris. We'll see.
That they're listed?
Judge, is it possible, I have to be in Detroit that morning. Is it possible to do it later, or is it possible to do it later, a different week?
I set this at noon.
You set these at noon?
Yeah, if all those people are coming.
Okay, I should be back from Detroit by then. Huh? My client is asking if we could do it sometime in December, but I'll leave, I'll leave it to the court's
Is there
discretion.
any objection from the people
No.
to a December date?
This is gonna be a problem. Can we do, I'm sorry,
Go ahead, Killawald.
is the 9th available? You being the considerate judge you
No, I've
are.
had to wait for you. I'm not considering at this point. 9th, you want? Will that work for the people?
Yes, sir.
Because I just need you to go away right now. Preliminary examination in person, December 9th, 2025, 9 AM. That is before Judge Valvo.
Thank you, Judge.
Bond continued. Thank you.
Yeah, next door.
Court calls the case, people versus Ariana Fenn.
Water Assistant Prosecuting Attorney for the people.
Yes.
Good morning, Your Honor. Jay Miller, P58658 on behalf of Miss Fenn, who appears via Zoom.
Yes, Ms. Fenn, can you state your name, please?
Ariana Finn.
All right.
Your Honor, and I apologize, I hadn't turned it into the clerk yet. I still don't have the video from the location.
So there's some discovery.
Some discovery still outstanding, yeah.
11th or 18th?
The 18th, fine, Your Honor.
Of course it is. December 18th, 2025, 9 AM, bond continued.
Thank you, Your Honor.
All right, thank you, ma'am.
Thank you.
Court does call the case of the people versus Christopher Decker.
Morning, Your Honor. Your Honor, could the court pass on this for a moment? There was a problem with phones and Mr. Decker hadn't been brought up yet. I haven't had an opportunity to speak with him yet this morning.
What are we going to then do on this?
I was going to ask to address bond and ask for an adjournment. We have his competence.
I'll pass.
Thank you, Your Honor.
Court does call the case people versus Amber Cormo.
Good morning, Your Honor. Jay Grant Miller on behalf of Ms. Cormos, who appears via Zoom.
State your name, please.
Amber Cormus.
Thank you. What are we doing?
Your Honor, we're still attempting to resolve this before exam. We're very close. I think another you want to give us a short adjournment, I think we might have it handled.
December 4th, 2025, 9 AM. Fine.
Thank you, Your Honor.
I'll need a green sheet on that. Court does call the case People versus Jamal Jones.
No water, Assistant Prosecuting Attorney for the People.
Yeah, John. Brandon Bird standing in for Randall Upshaw on behalf of Jamal Jones.
We didn't need a bell because I saw it.
Jones.
What? Your name?
Jamal Jones.
Thank you.
Intervention in lieu of conviction. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which essentially requires that you do what you're already doing at Tepe. You're going to complete a theft class, and you're going to pay this restitution. If you do all of those things and you refrain from the use of drugs or alcohol during the treatment period, then this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during this period, I can revoke the intervention in lieu of conviction and impose a sentence. Do you understand all that?
Yes, sir.
How old are you?
25.
How far did you go in school?
I graduated. I had a career center, Warren County Career Center.
Were you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No.
Are you taking any medications?
I take Suboxone.
Are you taking anything that would interfere with your ability to understand what we're doing here today?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what I've told you today, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with Ms. Diefenbach before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to enter a plea of guilty to 1 count of theft, 1 count of receiving stolen property. These are each 5th-degree felonies punishable by up to 12 months in prison and a $2,500 fine. If you violate the terms of your ILC and I do send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. But even were you to violate the ILC, I'm not saying that you're going to, but if you did, I don't have to send you to prison. I can still put you into my community control program. Before we go any further, Mr. Myers, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights, going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. Harris, did the state have the opportunity to consult with the victim in the case?
Yes, Your Honor.
All right, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about October 1st of 2024 through July 28th of 2025, in the city of Lebanon, Warren County, Ohio, the defendant, Travis Myers, was in possession of property of another without authorization from the owner. That value of the property is totaled at $3,580.
Anything on those facts, Ms. Diefenbach?
No, sir.
Mr. Myers, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the right you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
Going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which requires you to enter into and successfully complete the treatment at Tepe, plus any aftercare or additional treatment that is required. You're also going to complete the theft class. I am going to release you from electronically monitored supervision today, and I'm going to set restitution in the amount of $3,580. I do want to set this for a review hearing in about 6 months to see where we're at on getting that paid. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. and you're going to be subject to random drug testing. We have 14 days of jail time credit. Anything else?
No, Your Honor.
No, sir.
All right, good luck to you, Mr. Myers.
Thank you.
Now, does he report to precinct?
Yes.
Okay,
So go back there.
you go back, yeah.
Okay.
Good luck.
Yeah, thank you.
What are we doing?
But, Your Honor, respectfully, asking for that adjournment to December 18th, I believe.
Got it. Is he a co-defendant?
Yes, Your Honor.
With the other one? And the other one I set to the 18th.
Correct, Your Honor.
Probable cause conference will be adjourned December 18th. I'll need a green, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
Court does call the case People versus Vasquez Davis.
Prosecuting attorney for people.
Brian Bowen, Assistant Public Defender on behalf of Mr. Davis. Just need your name for the record, please.
Yes, sir. Vasquez Davis, sir.
Judge, I'm just asking for an adjournment. I don't have any discovery yet. What's the matter?
No discovery on this one. Okay. December 11th, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
All right, thank you. Thank you, Chuck. You do the same. Court calls the case People versus Noah Bowen. You guys need to keep that aisle clear for transport if you can. All right, thank you.
I'm here for Mr. Bauer and Judge. I didn't hear if the prosecutor had put his appearance, but Wade Fink from Mr. Noah Bauer on Zoom.
Your name, sir?
Noah Bauer.
All right, what are we doing?
Your Honor, it's my understanding that the prosecutor on the case, Miss, is it Zendel Alley? Zenda, she is on vacation or leave. I sent a list of discovery requests. I recognize that this is the third PCC, but I tried to send the list after the last one. Maybe I was a little aspirational about doing it a week later, but I'm still without full discovery until the prosecutor's office has a chance to go through the balance of the requests. So I'm okay setting an exam if they have enough time to get it to me, but this is based on their discovery, what I think I'm still missing.
We did receive a discovery request from defense counsel. We need to go through that information and see if anything, we have any of it, or can obtain any of it. So I don't.
So you're still sifting through. And Ms. Zenda's just on a special project. She'll be back.
No, I understand. I didn't mean to suggest anything, anybody's fault. It just takes time.
She was gonna go anyway, didn't matter. She was the only attorney that could handle that.
Understood.
All right. How much time would you need to kind of sift through that, counselor?
Yeah, I don't want to pick my date. Maybe
No, go ahead. Pardon?
early December.
Okay, why don't I do this? Probable cause conference, December 11th, 2025, 9 AM. Bond continues.
Thank you, Your Honor.
Sir. Court calls the case People versus Jaleesa Robinson.
We're gonna read it to people.
Sit
There you go. This is Mr. Miller again. Ma'am, Ms. Robinson,
Yes.
I'm gonna pass your matter. I don't know where your attorney went.
Okay.
I think you may have stepped in the lockup, Judge.
Okay, so I'll pass your matter, but we'll get you called up, right? Thank you. Court does call the case, People versus Timothy Lacy.
Best fellows with people.
Good morning again, Your Honor. Robert Ellman with and on behalf of Mr. Lacy, who is approaching.
Your name, sir?
Good morning, Your Honor. Timothy Lacy.
Thank you.
Your Honor, at this time, we'd like to set this matter for exam.
Discovery is complete.
Yes, Your Honor. Your Honor, I believe there's a co-defendant in this matter. I would also like to have a separate exam from that co-defendant.
And I request they be sent together, Your Honor.
Of course. What would be the reason for a separate exam?
My understanding, Your Honor, after reviewing discovery that the co-defendant made statements to the police that I guess would be admissible in a joint exam that may not be admissible against my client in a separate exam.
Certainly at trial, there may be an issue, but for exam purposes, we're gonna run into that issue. I mean, I think whoever the judges can sort out whatever statements may be made and their proper use at exam. So I don't see a necessity necessarily that they need to be separated.
Fair enough, Your Honor.
Is the co-defendant set for exam at this point or no?
I think he's also up this morning, Your Honor, calling the name now. Apologize.
That's okay.
Mr. Jones, I believe is up as well. Morning.
His counsel.
I believe that's Mr. Bernstein.
Pardon?
I believe that's Mr. Bernstein.
Correct. Mr. Bernstein for Tamarian Jones.
Okay, but we don't know what they're,
I have not spoken to Mr. Bernstein about a date. He's in lockup.
He's out in the hall.
He's in the hallway. May I go get him, Your Honor? He's-
yes. Things were.
Thanks, Your Honor.
I think that's right. We have who? What's the first name on the? Jones?
Tamarian. So he was represented by Adam Clements, his attorney Justin Andrews. Oh.
And Officer Williford from probation, you're here today for sentencing. Has everybody had the opportunity to review the PSI?
Yes, Your Honor.
Any reason not to go forward with sentence today?
There is not, Your Honor. No, Your Honor.
47 days of jail time, credit time, right to everybody.
Yes, Your Honor.
I'm not getting credit for that. 47 days.
Do you need a minute, Mr. Schiavone?
I'm sorry, Your Honor.
Do you need a minute with Mr. Gonzalez Rodriguez?
Just one moment, Judge.
Okay.
You only get credit for the time you serve as warrant. Even though I had a whatever. Even though you had a yeah. That is the law. Very good, Your Honor. Thank you.
All right. Anything from probation?
Nothing further, Your Honor.
Mr. Harris, anything else?
Your Honor, as I stated in chambers, there was an attempt to contact the victim in this matter. There has been no response. The items were recovered along with the vehicle. Your Honor, in regard to this case, as you're aware, there's immigration consequences. That is ongoing. There is an ICE holder on this. However, as the court's aware, the defendant has been deported before and come back to the country. I think the concern of law enforcement is that may happen again. Certainly, we don't want this to be a revolving door. We do believe consequences are in order. The implication that I have is that he's connected to a larger theft ring, and we're talking about new vehicles, millions of dollars is what I've been told. So again, the state's concern is this is a revolving door for him. There was some indication in chambers as well that he wants to become a citizen at this point. Certainly law enforcement is concerned that he'll be back in the community.
Mr. Schiavone?
Well, Judge, I think you made it real clear that if he violates any law, you've got 36 months looking at him, which is a real deterrent. This gentleman has served 8 months in jail, not only through Warren County, but through the federal case, which has been completed. He received time served, and ICE is getting ready to deport him. I don't know where the $1 million number is coming from, Judge. This gentleman was involved with a car, a Charger, Dodge Charger, which was a Challenger, excuse me, which was returned, I believe, undamaged. We would ask that the court, I would incorporate the comments made in chambers and ask that the court follow the recommendation that, or the statement that was made during the plea.
Mr. Gonzalez Rodriguez, is there anything that you would like to tell me?
As far as sentencing?
Anything you want to tell me? Now's your time.
I just want to apologize for my actions. I'm sorry for everyone here. I'm sorry to the community for my actions. I know it might just appear as like another case number to you, or maybe even a criminal, but I'm much more than that. I'm a father. I'm a son, and I'm a fiance to my beautiful girlfriend in the courtroom. I grew up in this community. I started first grade here in Mason. I finished school in Mason. I have done bad things, that's why I'm here. But I've also done a lot of good things in this community. I've helped build hundreds, if not thousands, of homes in this community. Most of my life I've done real good. I have slipped up. I'm not a perfect person, but I admit I was wrong, and I just want to be able to be home for the holidays with my family, even if it's not in this country. It's very clear to me that if I do come back to this community or this country and commit a crime, that I will be doing jail time. And that's enough to get me out of the way. My daughter's, she's 8 years old, my son's 4, and I have another son who's 2, and I've missed a lot of time away from them. I came here wearing winter clothes. I'm going to be leaving wearing winter clothes, and I don't want to come back to jail no more.
So here's where we're at, Mr. Gonzalez Rodriguez. There are a lot of things at work in your case that don't have anything to do with me. The allegation that this is $1 million ring, that you're involved in some big thing, I don't have anything to do with what you pled guilty to in this case. Maybe, but it's certainly not proven to me. All of the issues that you have with your immigration, that's not really my area either.
Okay.
You know, you took a car, 47 days of jail. I know you've been incarcerated a lot longer than that, and I'm taking that into account. You know, I just want to make sure that you don't steal any more cars or commit any more crimes. What the United States government does with you, that's their business. I'm going to put you on 5 years of non-reporting probation. I'm going to give you 47 days of jail time credit. We're going to run your record every 6 months. If we find that you are somewhere or have committed a new crime, you're going to answer to me in this case for up to the maximum penalty in the case, which is 36 months in prison. You do have the right to appeal this to the 12th District Court of Appeals in Middletown. If you don't have the funds to hire a lawyer to obtain a transcript or to pay the costs, they will all be provided to you at no charge. I am going to release you to your ICE detainer. I'm going to order that your personal property be released to your mom, who is Erica Rodriguez, and that the bond that was posted in the case be returned to Emily Diaz. I don't know where your property is, but if somebody's got it, we'll get it back to you.
All right, thank you, sir.
All right, that's all. Good luck to you, Mr. Gonzalez Rodriguez.
Thank you.
Next is the case of the State of Ohio versus number 24 CR 42247. Present before the court is Mr. Whitaker, represented by Ms. Shy, and we have Ms. Hyatt from the prosecutor's office, Officer Bridgman from probation. We are here today, Mr. Whitaker, because your attorney has filed a motion requesting something called intervention in lieu of conviction. We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to these charges, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which includes outpatient treatment. You're going to follow the rules, and you're going to refrain from the use of drugs or alcohol during the treatment period. If you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol during the treatment period, then I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that? How old are you?
46.
How far?
47.
How far did you go in school?
I've got my GED right now. Great.
Are you able to read and write English?
Oh, yes, very well.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
Has anybody made any threats, promises, or representations to get you to plead guilty to this against your will? I have a document entitled Change of Plea and Entry. On the second page, there's a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review that with Ms. Shai before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Very well.
You're going to enter a plea of guilty to 1 count of trafficking cocaine, 1 count of possession of cocaine, and 1 count of possession of criminal tools. Those are each fifth-degree felonies, punishable by up to 12 months in prison and a $2,500 fine. If you do violate the terms of your ILC and I send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. But even were you to violate the ILC, and I'm not saying that you're going to, but if you did, I don't have to send you to prison. I could still put you into my community control program. Before we go any further, Mr. Whitaker, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to these charges, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do? Ms. Hyatt, what are the facts?
Your Honor, if this case had proceeded to trial, the state would have shown beyond a reasonable doubt with respect to counts 1 through 3. They all occurred on July 16th of 2024 during a traffic stop in Springboro, Warren County, Ohio. With respect to count 1, the defendant, in this case Jason Whitaker, did knowingly transport a controlled substance when he knew or had reasonable cause to believe that the controlled substance was intended for sale or resale by himself or another person. This case, with respect to count 1, it's cocaine, and the cocaine that was found is 3.58 grams of cocaine found in his motor vehicle, along with a scale and some empty small Ziploc baggies. With respect to count 2, he did, during that same stop, did knowingly possess the cocaine. Again, it was 3.58 grams. And with respect to count 3, he did possess a substance or a device. In this case, it was the scale with purpose to use it criminally. It would be then for the trafficking, for the weighing of the cocaine.
Anything on the facts, Ms. Shai?
No, thank you, Your Honor.
Mr. Whitaker, did you hear those facts?
Yes, sir. Your
Do you admit that they are true?
Yes, Your Honor.
Do you understand the right you're giving up by entering a plea? Is that a yes? Which plea?
Guilty. It's my first time for me.
That's okay. You're doing fine.
I'm sorry.
All right, I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. Mr. Bridgman, any recommendations from the treatment plan?
Your Honor, just to follow the treatment assessment, which was outpatient treatment for substance use.
All right, I am going to adopt a treatment plan in the case. I'm going to stay the proceedings for a period of 3 years. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. And you're going to be subject to random drug testing. You're going to enter into and successfully complete outpatient treatment. And I'm going to give credit for the 3 days you've already done. Good luck to you.
Thank you, sir.
Do you want to go see if we want to get a new date?
Yeah.
Okay, I didn't know if you had time.
thought it was Mr. Bernstein case. I apologize, Your Honor.
I believe it
Mr.
was the mayor
Andrews.
retained counsel.
Mr. Andrews,
Yes, good morning, Your Honor, to you and your staff. How are you doing, sir?
I'm doing well. You are representing Tamarian Jones?
This is Tamarian Jones. Yes, I'm standing in for the attorney of record, Attorney Adam Gregory Clements, on behalf of Mr. Jones. And it's our intention to set this matter for an exam, Your Honor.
Gotcha. Okay. So when we get to that case, I will do that. I've got the co-defendant out here at this point. So I will, in all discovery to your knowledge, counsel, on your case is complete.
My understanding, yes, Your Honor.
All right, very good. So what I will do is I will set preliminary examination in this matter in person. That will be set for November 25th, 2025 at noon.
Your Honor,
And that is, go ahead, sir.
my apologies, Your Honor. Attorney Clements was asking if the matter could be set beyond next week. He is in a trial, so I just don't necessarily know if that's beyond next week.
Well, the 25th is beyond next week.
Okay, thank you very much, Your Honor.
All
That's
right. So, all right. So I'll set it the 25th at noon, and that is before me.
Okay, thank you so very much, Your Honor.
Right. And bond will continue. I'll still have to call your case because your client's not out. I was setting the co-defendant. And as soon as we can get Mr. Jones out, then we'll just set it. But he's got to be here to hear everything. All right.
Thank you very much, Your Honor.
All right. So if you can hold on, it'll be great. Thank you. Bond in
Thank you,
this
Your Honor.
matter will continue. Court does call the case People versus Daryl Jarrell.
Kyle Burrell on behalf of Mr. Jarrell, who is approaching the podium.
Bench warrant. Was there a case you didn't appear on that he issued? I don't know. Go ahead.
Thank you, Judge. We are here for a probable cause conference. I'm asking that there be a brief adjournment in the matter.
All right, that's fine. Jarrell, how you doing? Morning, Jarrell. Any objection from the people? I'll adjourn it to December 11th, 2025 at 9. His bond will continue. We may want to, we adjourned his other ones to what was, he wasn't here though. I don't think he appeared before me. You didn't appear before me, Mr. Jarrell, on your other cases, did you?
Oh, no, it's still pending December 3rd.
Pardon?
December 3rd.
December 3rd. Okay, good enough. I don't think I saw you, and I just wanted to make sure there wasn't a bench warrant out there.
No.
Okay, unless you want one.
No, sir.
Okay, all right, I'm just checking.
Try to keep them off.
I try to just please everybody, so if you wanted one, I would give you.
sir.
All right, you're all set.
Thank you,
We'll
Judge.
see you on the 3rd.
I'll see you in the hallway.
Oh, yeah. Okay. Let me do this. Court does call the case People versus Devontae Owens.
Good morning, Your Honor. Ashley Phelps with People along with.
Good morning, Your Honor. Brandon Bird on behalf of Devontae Owens. Please, full name for the record, Devontae Owens.
Okay.
Your Honor, co-counsel Mr. Evans was able to speak with Mr. Bird this morning, and I understand there's two updates to the court. The subpoena motion has been withdrawn, I think, by Mr. Bird, is my understanding. I don't want to speak for him, but I think that's what's happening. And then the people are also going to be filing a motion that we'd just like to give defense a chance to respond to. So ultimately, we're looking for another PCC date.
That's correct, Your Honor.
All right, so what type of motion are we going to be filing?
It's a motion requesting in-camera review.
Gotcha. How soon will you have the motion?
Today.
Today, okay, you'll have the motion today,
I just
and,
want to speak to Mr. Bird about it first before we go.
and Mr. Bird, if I give you a couple weeks to respond, you'd be able to,
Definitely.
okay. And so then why don't I do this? If there's gonna be a motion set on it, then I'll indicate there's a motion coming forth. I'll set this probable cause conference then for December 18th, 2025 at 3 p.m.
December 18th.
Yes.
Thank you, Your Honor.
And you say on the 2 o'clock, Your Honor?
3.
3 o'clock.
Don't be lurking around here at 2. No, I'm kidding.
3 o'clock on the 18th, Your Honor.
Yes.
Thank you so much.
Thank you. Bond will continue on that case.
May not got to tell you, but I got enough change in my pocket.
You got it, okay. All right, folks, we're graduating. I have to take a brief break. Everybody can remain seated and then I'll.
Just let me know I have an update about this. Thank you. Great.
Engineer. Court calls the case, People versus Engineer, right?
Ajane, right? Morning, Your Honor.
This
This talks about Ajane, right?
Not signed. Where is Miss Ray?
They're done and she's very soft.
Miss Ray, are you there?
Ajane, right?
Okay, thank you. All right, what are we doing on this?
Your Honor, we'd like to set this for a preliminary exam, but we are also interested in stipulating to Ms. Wright appearing by Zoom because she's in Minnesota, rather than having her writ here in person.
Where is she now?
Minnesota.
Pardon?
Minnesota.
And Your Honor, people have no objection to that, the court would allow it.
I will set the exam, but you're gonna have to speak with the judge it's assigned to as to whether or not the judge is gonna permit that. I don't see why they would not.
Okay.
All your discoveries complete.
To my knowledge.
Would the people have their witnesses available the 25th?
Your Honor, just given with the federal shutdown, she's in federal custody, could we get a little?
That's over.
I know, I'm just concerned other things.
No, I guess it isn't. I guess it isn't. Never mind, my bad.
If we could just get maybe another week or two in addition to that, just for that transportation rate, in case transportation is necessary, if we do need to bring it here in person.
Got it. Why don't I do it this way? Preliminary examination, I'm gonna mark it in person for December 16th, 2025, 9 AM before Judge Fresh Hour. And so you would have to contact Judge Fresh Hour's chambers regarding appearance of her by Zoom, if that's what you intend to do.
Understood.
All right? Thank you.
Thank you.
Bond continue. Did you get the signature? Oh, I don't need it because I said it for today. Court does call the case People versus Darius Embry.
David I. Goldstein appearing on behalf of the defendant.
Your name?
Gary Simbry. Good
All right,
morning.
what are we doing?
Setting for an exam, Your Honor.
Discovery is complete.
It is, Your Honor.
People have their witnesses available the 25th.
Your Honor, I'm going to be gone the next 2 weeks for the holiday. The first Tuesday that I'd be available would be the 9th.
So, I mean, okay.
I could Zoom, Judge. That doesn't matter.
No, right, that's not, that could be me. All right. December 9th. Preliminary examination in person without objection, December 9th, 2025, 9 AM. That's before
Judge Washington.
Judge Washington.
Thank you, Your Honor.
Bond continued.
Okay.
Court calls the case of the people versus William Riddle.
Morning, Your Honor. Jay Grant Miller on behalf of Mr. Riddle, who approaches. Please state.
William Michael Riddle.
Your Honor, we're requesting an adjournment because like so many others, we have no discovery in the case.
Probable cause, December 11th, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
We had one of your other cases. She was it Robinson?
Yes, Your Honor.
Court recalls case people versus Jaleesa Robinson.
Good morning, Your Honor. Jay Grant Miller on behalf of Ms. Robinson, who appears via Zoom.
Ms. Robinson, oh, there she is. State your name, please. Nita.
Robinson.
Thank you. Also, you're requesting an adjournment on this.
Yes, Your Honor. I understand. I think Ms. Robinson's been before the court a bunch of times, but I was just appointed on this, so I don't have the discovery yet to talk to her about the case.
Got it.
So quick adjournment if we want to put that up.
Cause conference, December 11th, 2025, 9 AM.
Thank you, Your Honor.
Thank you. Thank you, Ms. Robinson, for your patience. Court does call the case versus Bobby Tennyson.
David I. Goldstein, appearing on behalf of the defendant.
Your name, sir?
Good morning, Your Honor, Bobby Tennyson.
All right, take your hands out of your phone. He gets upset. All right. Okay. You're requesting an adjournment on this. This is a discovery issue.
Yes, Your Honor. It's not quite the same as some of the others. I did get 197 pages of discovery like yesterday, the day before. And there's a bunch of videos that I just got that I'm having trouble downloading, but that may be me, not the system.
Oh, I'm sure it is. All right. All right.
I'm looking for December 11th, if that's okay with the court.
All right. December 11th.
Thank you, Your Honor.
2025, 9 AM. Bond continued. Court calls case people versus Adonis Sweat.
Judge calls for the people.
I thought I saw her. Somebody go out to get her.
Mr. Evans went to go get her, Your Honor. Mr. Evans went to get. Sorry.
I know, but they're arguing. Miss Barnwell?
Hey, I'm with the investigator.
Court calls case or recall case of Donna Sweat.
Judge calls for the people and.
Good morning, Your Honor. Wendy Burnwell, P42505, on behalf of Mr. Adonis Sweat.
Adonis Sweat. Thank you. All right, what are we doing?
Your Honor, Mr. Sweat is the co-defendant of Mr. Devontae Owens, where the court just set a motion hearing for December the 18th at 3 p.m. to file a motion review. I believe, I don't know what the plan is for Mr. Sweat, but I wanted to first have that context.
All right. So that is set out to the 18th. Is there a similar motion that's going to be?
Not as to, oh, sorry. Not as to that, Judge.
Okay. So what do you want to do? I can adjourn his to that date. I can.
That would be the request of the people.
I thought that we were gonna get an exam date at some point, but it looks as though I misplaced my phone. which has my calendar on.
Oh, I see. Okay. You should get like Miller and get a watch that has it. So what would you like me to do on this? I can put it over to the 18th because we're looking to likely have them tried together, but I mean, I can give you an exam. Well, I hate setting an exam date even after that 18th date because I'm not sure what the full context of that motion is.
We can put it over to them, Judge.
To the 18th. All right.
It's 9 o'clock.
Probable cause conference will be adjourned to December 18th, 2025. I set that at what?
3 p.m.
At 3 p.m. I set that in the app.
When I get paid. Not a dime, nobody paid me.
Miss-
Okay. Gotta have money to.
No, I set that in the afternoon at
Yes,
3.
at 3. Thank you.
Bond will
Okay.
continue. Thank you.
I'm good.
Court calls the case, People versus Taylor Buyer.
Yes, Your Honor, Brandon Byrd on behalf of Taylor Buyer. Mr. Buyer, can you please state your full name for the record?
Taylor Buyer. Thank you. You're requesting an adjournment on.
Please, Your Honor.
Probable cause conference will be adjourned December 18th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Have a great day.
You too. Have a great day.
Thank you.
Court calls the case, People versus Devontae Gambos. I'm sorry, I did not love to see it.
Mary Rubio on behalf of Mr. Gamble. I'm standing in for his attorney of record, David Burgess, with his consent. Is that correct, sir?
Yeah.
Could you please state your name?
Devontae Gambos. Thank you. What are we doing?
Today is the PCC and we are requesting an exam date.
That's an exam or during PCC?
I think Mr. Burgess told me to set it for exam. Are you?
Just not what we discussed.
Oh, I'm sorry. If that's not the case, then
That's not what you and I discussed. But if that's what he wants, it's fine.
I'm sorry. I thought.
I don't know. I need to hear this whole conversation. What
No,
do
you
wanna
did
do?
not. I'm sorry. He just told me to set it. I apologize. I thought that's what, but anyway, yeah, he said to.
Set it for an exam.
That is what he said.
All right. Discovery is complete. To the
Yes.
best of your knowledge. And would people have their witnesses available the 25th? Preliminary examination in person, November 25th, 2025.
What, and I'm sorry, is that at 9 a.m.?
9 a.m. with Judge Fresh Hour.
Okay.
But
I'm sorry, Your Honor, I've spoken to Mr. Gambles and he has asked me to address bond. He's indicated that he is having an addiction issue and he asked if he could be transferred to a treatment facility.
I would, if he wishes release to treatment, if that standard order, which would include a tether, is provided to the court, I don't have an issue signing off unless there's an objection.
There isn't, there would be an objection. Your Honor.
Pardon?
There would be an objection to this matter.
On what grounds?
He's charged with armed robbery. He is one of the leaders in this. This was a premeditated home invasion, armed robbery with a firearm. He was on probation for a gun offense at the time. I think we make up for that. He has a history.
Counsel, if you really want that, raise it as a motion before Judge Fresh Hour to be heard on the date of the 25th.
Okay, I will make a note of that. Thank you.
Thank you.
Court calls the case, People versus Tanisha Aiken.
People. On behalf of Ms. Aiken, who should be on Zoom. Ms. Akins, can you please unmute, turn on your camera and say your name for the record?
Why you can't do stupid shit?
That's your name?
Tanisha Akins.
Should be on Zoom.
Tanisha Akins.
Thank you.
Your Honor, we had adjourned this case last time to give Ms. Akins time to make.
Counsel approach, please. $2,000 fine plus court costs. Is that your understanding?
Yes, sir.
And you understand that?
Yeah.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, as we talked about. You'd be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind?
Yes.
Counsel, I don't have an advice or right.
Oh, I'm sorry. I really apologize. I thought everything was already in the file. Okay.
You think she did it?
I think so. Can I see that?
Ma'am, did you sign an advice of rights form previously? Yes, she did. I got it.
Okay.
You remember signing one?
Yes.
Any questions regarding any of those rights?
Yes, sir.
All right. Look on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand, pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Probation.
All right. Were you on probation at the time of this offense?
Yes.
All right. I do have to advise you that your entry of a plea in this case could be considered a violation of that probation. You understand that?
Yes, sir.
And if it is considered a violation, that other court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Yes, sir.
Understanding that, do you still wish to plead guilty to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody?
Asking that you give her another opportunity to be out, to comply with pretrial services with whatever technology the court finds would be most beneficial to her, to make sure that she appears. Our hope is to be able to resolve this with some preliminary negotiations that could result in potentially a misdemeanor plea, and we would like to come back hopefully in early December for another pretrial.
All right, the state have a position?
Your Honor, we have no objection to that. The only thing in addition is there was not a no contact order issued at arraignment, so we would ask for no contact order with the victim, Jesse Carter.
This is the person that lives in Florida.
Yes, Your Honor.
All right, Miss Teagarden, the reason that your bond was revoked is because when you got out of the jail, you signed a document that says that you would report immediately to pretrial services, and then you blew them off. And then after they sent you an order to report, you again failed to report. That's why your bond was revoked. So I'm going to reinstate your bond today and put you back on pretrial supervision. If you're not going to follow the rules, then you're going to be back in the Warren County Jail. I'll revoke your bond again.
Yes,
And we won't have this conversation a second time. Do you agree?
Yes, sir.
All right, so as soon as you are released from the jail, you are immediately to come over to this building and report to pretrial services. Do you understand?
Yes, sir.
Okay, that's all.
513.
And you understand that?
Yeah.
All right. You understand also that while I'm taking your plea, I would not be your sentencing judge, as we talked about. And you'd be sentenced before Judge Washington in the 14B District Court. You understand that?
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
Counsel, I don't have an advice right.
Oh, I'm sorry. I really apologize. I thought everything was already in the file. Okay.
You think she did it?
Can I see that?
Ma'am, did you sign an advice of rights form previously?
That,
Yes, she did. I got it.
Okay.
You remember signing one?
yes,
Any questions regarding any of those rights?
yes, sir.
All right. Look on the podium. Please look at paragraph 5. Those are your rights which are part of a trial. You understand, pleading guilty, you'll be giving up those rights as well as all the rights contained on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
Probation.
All right, were you on probation at the time of this offense?
Yes.
All right, I do have to advise you that your entry of a plea in this case could be considered a violation of that probation. You understand that?
Yes, sir.
And if it is considered a violation, that other court could sentence you to the maximum allowable under that other charge or charges. You understand that?
Yes, sir.
Understanding that, do you still wish to plead guilty to this charge?
Yes, sir.
Anybody promise you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will?
Yes, sir.
All right. And also because you believe you're guilty?
Yes, sir.
Only day, really, people. Putting together this file. On the date of March 12, 2024, Holmes Road near Twin Tower Street, Ypsilanti Township, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, sir.
Had you used it?
Yes.
Did you know what you were using was cocaine?
Yes.
All right, ma'am, I do have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of sentencing, the court would not be bound by any sentence evaluation or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
I am not.
All right. And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
December 11th at 10 a.m.
December 11th, 2025, 10 a.m.
Your Honor, may I address bond?
That is before Judge Washington, briefly.
Your Honor, it's my understanding that Ms. Guyton has been remanded, and I understand that's kind of due to her own actions, but I did want to just advise the court that I've spoken to Ms. Guyton. She has a lot of health issues, including cancer and blood clots. She has not had her medication for her blood clots. She indicates that she was participating in, and if she is released, she would continue to participate in the substance abuse program through Huron Oaks.
All right. And we went through this a couple of times with this guy. And so I'm not going to change my bond in this case, certainly after her pre-sentence interview, that can be looked at by Judge Washington.
I understand.
So at this time, her request for bond reduction is denied.
Okay, I understand.
Thank you.
Don't know money at all.
They're gonna give you next.
Court does call the case People versus Melinda Baker.
Kenneth Waters, Assistant Prosecuting Attorney.
Good morning, Your Honor. Zach Finney on behalf of Ms. Baker, who appears via Zoom, requesting permission to practice pursuant to Michigan Court Rule 8.120 under Assistant Public Defender Asli Bashir.
Where's Bashir? He's not even here.
In that case, under Assistant.
You're gonna pick another one?
Assistant
Oh,
Public
no, go
Defender.
ahead, pick one. Let's see if they're here. Who?
Stephanie Cannon, Judge. Oh.
People with.
Yeah, I don't know that that's gonna work. I don't know. I don't know that I can grant that. Permission to practice is granted.
Thank you, Your Honor.
Mr. Brown's coming up, and he's not like He is not trying to step in. He's just saying, "No, I'm here."
Ms. Baker, can you please state your name for the record?
Melinda Baker.
Thank you, ma'am.
Your Honor, we would request an adjournment for negotiations with the people.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m.
Thank you, Your
Will
Honor.
continue. Thank you. Thank you, Ms. Baker.
Thank you.
Court calls the case, People versus Tamarian Jones.
Morning, Your Honor. This is Justin Andrews.
Thank counsel. Up there, I don't see you, but go ahead, counsel.
Yes, Your Honor. Justin Andrews, P 81445, on behalf of Mr. Tamaria Jones, standing in for the attorney of record, Attorney Adam Gregory Clements. Your Honor has set this matter for an exam the 25th of November. Mr. Clements is just asking for that time to be later in the afternoon, as he has a motion hearing earlier that day, Your Honor.
Well, I have it set at noon.
Okay, that should be fine.
All right, so here's what we'll do. You understand that, sir?
I didn't hear.
Didn't hear, okay. So you're setting it for preliminary examination prior to your coming out so that the record is clear. They had indicated discovery was complete and the people indicated that they have their witnesses available. So for your co-defendant, we were dealing with a co-defendant's case. We set it, your counsel was present at that time. And so we were waiting for you to be able to be brought out, and we're setting the exam at the same time. And he was just clarifying some things regarding it. Does that make more sense to you?
Yes, sir.
All right. So preliminary examination in person will be set November 25th, 2025 at 12 noon. And that is before me.
Thank you, Your Honor.
All right.
Your Honor. Have a great day.
Thank you. Pardon?
I said, have a great day to you and your staff, Your Honor. Thank you.
All righty. Thank you, sir. Court calls the case People versus Jordan Bishop, Easterling.
Brian Bowling, Assistant Public Defender, on behalf of Mr. Bishop Easterling with the Courtrooms.
Never mind.
No relation.
Another person. Your name, sir?
Jordan Bishop Easterling. Judge, I'm asking for an adjournment in this matter as well, as I don't have any discovery.
This is it. All right, so what I'm gonna do in this case, probable cause conference will be adjourned December 18th, 2025, 9 a.m. All right, sir.
Thank you, Judge.
Thank you. Thank you, sir. Court calls the case of the People versus Sean Grisby. Or it's Gabbries, excuse me.
Christina Costantino appearing with and on behalf of Sean Gabbries.
Oh, she's here.
I am here, Judge.
Oh, you're so short. I didn't see you.
Oh, that's okay.
No, I'm.
I even wore the heels today.
I know. Well. All right.
Sean, can you state your name for the court?
Sean Gabriel.
Thank you.
You're requesting an adjournment.
Yes, Your Honor. I believe there is some outstanding discovery, specifically some cell phone extractions, a forensic interview that's outstanding, and potentially some body camera footage. Mr. Kennedy and I have spoken about that, so they are aware of that.
Okay, so if I set it for the 11th, can we have all that cleared, or?
I'm not so confident about the cell phone extraction. I don't know how long it's going to take. Body cam and the forensic interviews are easier.
Easier to get.
But the cell phone extraction, I sent a text message to Detective Morrison. I would see what I can do about it.
I'd ask that we at least try for that date, given he's in
11th, okay.
custody. And if at that point,
And
if
at
we still
that
don't
point,
have
we
it,
can make
then
an assessment as to what, okay, that
Sure.
makes sense. Probable cause conference, December 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, Judge.
Court calls the case of the People versus Bobby Black.
People. Morning, Your Honor. Mike Getty, defender on behalf of Mr. Black, who's here via Zoom, Judge.
Mr. Black. State your name.
Bobby Black.
Thank you. Requesting an adjournment.
Yes, Your Honor. I need to, I have received discovery. I've reviewed it. I need to review it with Mr. Black. He's currently not available. He should be as of the 19th. He's in Kalamazoo at the Enlightened Therapy site.
I'm sorry?
He's in Kalamazoo at the Enlightened Therapy facility.
Okay, so you want something after the 19th or you want,
Yes, that would be preferable, Judge.
you're talking the 19th of November?
Yes, Judge.
All right, gotcha. All right, well, why don't I set it for the 20th? No, that's next week. We'll set it for the 4th. Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you, Mr. Black. Thank you. Court calls the case People versus Christopher Decker.
Morning, Your Honor. J. Grant Miller, Key 58658 on behalf of Mr. Decker, who approaches the podium. Please state your name.
For Decker, Your Honor. Sorry about that. This is time for a competency review for evaluation. All right.
Yes, Your Honor. We received the report from the Forensic Center. We'll stipulate to their findings as it relates to competency. I don't believe that people are objecting.
And that's correct, Your Honor. Simply, I believe it's the October 6th report.
Yes, it is.
Yes, and I would note that the criminal responsibility report has not been prepared yet, but we expect that will be arriving at some time.
All right.
But Mr. Decker, actually, we've been attempting
Well,
to
let
try.
me make my finding. The report in this case indicates that the defendant is competent to stand trial. Court would find that the defendant is competent, can understand the nature and objects of the proceedings against him, and can rationally assist in his defense. Therefore, he's deemed competent. Counsel, I'm going to need an order when you get a chance to file that.
Yes, Your Honor.
What would you like the court to do with this?
Your Honor, we're requesting an adjournment. This case was tracking another matter that Mr. Decker already had set for trial. And that was supposed to be, I believe, about last week. That got adjourned to January the 9th. And we can't try and resolve this case until that case is off of the table, apparently.
Is that a circuit court trial?
It is.
Is he being held on that case also?
Actually, he was granted a personal recognizance bond in that case, but we weren't addressing bond yet. I would like to if I could, though.
Go ahead.
Your Honor, in the circuit court case that is scheduled for trial on January the 9th, my client was granted a personal recognizance bond with GPS tether. I know he has a $25,000 bond in this case, and I know that people are going to oppose what I'm going to request. We'd request a personal recognizance bond in this case with GPS tether and no contact with Martin Tingley, of course, but also Ozone, which is a treatment facility out here in Washtenaw County, has a bed for my client. So we're asking that he be tethered to the Ozone treatment facility where he could continue to with his mental health treatment and substance treatment programs that he's been affecting through the jail. He also has been speaking with Tiffany Davis. I believe the court's well aware of her work with the Washtenaw County Sheriff's through community corrections. They have a plan for him, a daily routine set up so he can try and continue with some of the treatment that he's been working with in the jail as best as he could. We're just asking him to have a PR to Ozone with the GPS so he can continue.
Your Honor, I understand that you want to do a PR bond in the circuit court case. It is unusual, but I am going to be objecting to a PR bond here. In this case, this is an assault case. He has two other pending assault cases. He has one in the 15th district for an aggravated assault, and then there's the circuit court bench trial in January, which is an assault, great bodily harm by strangulation, as well as domestic violence third.
Who is that case before?
Judge Conlon.
Okay.
In addition to that, I do see a pretty significant concerning history going back to 2020, including concealing carry of weapons, felonious assault, possession of controlled substances. Obviously, he has at least two prior domestic violences, domestic violence third. He has a prior fleeing and eluding, resisting and obstructing. I believe he was actually on warrant status at the commission of this offense. And so I'm just concerned with the release of treatment about his ability to remain a safe member of the community, as well as ability to show back at the court.
Isn't that the same concerns that the circuit court would have had?
Maybe I wasn't present for the hearing. I don't know what was put on the record. I don't know if that court had additional information that led it to grant a PR bond. Based on what I'm seeing here, I disagree with that decision. I understand it was made.
I'm sure Judge Conlon cares. Go ahead.
That's my position. I would have then released a treatment of change in bond at this time.
But okay.
And I did speak with brother counsel who's handling the circuit court case yesterday in Judge Conlon's courtroom, who indicated that the court did see fit to grant him the personal bond with the conditions of the GPS tether. They actually didn't even require him to go to Ozone under that bond, but he does have a bed available for him at Ozone. And I understand this court's concerns about some of the behaviors in this incident. So that's why we're requesting the GPS to the Ozone. They have a bed for him, and he's already been trying to get in touch with everybody to make sure he stays on a treatment plan if he is released, Your
Honor. In this instance, probable cause conference, I'm going to adjourn. You said that trial is set for January
9.
I'll adjourn this probable cause conference to January 15th, 2026, 9 a.m. I really hate to go out that far, but what I will do, however, is I'm going to grant the motion to modify the defendant's bond. I'm going to release him on a personal recognizance bond with a GPS tether. However, the one distinction between what maybe is done in circuit court, he is required to go to Ozone House for treatment.
Yes, Your Honor.
All right. Thank you. Court calls case People versus Spencer Norton. Chief cases.
Morning, Your Honor. Edward Dukes on behalf of Spencer Norton.
There's Mr. Bashir.
Hi. Ashley Bashir on behalf of Spencer Norton in the matter ending in
Your intern. He said he had no idea where you were. And that he almost made you sound like a fugitive. It was horrible. I defended you though.
Thank you.
You're welcome.
Thank you, Your Honor. I appreciate that. But yeah, that was my fault.
Mr. Norton does not want to come up.
Well, we were going to ask for an adjournment, so it's okay if he doesn't go up.
Yeah, okay, gotcha.
There.
All right. I'll grant your request for an adjournment. How much time did you?
2 to 3 weeks. We're trying to reach a global.
Okay, gotcha.
It could be 4.
It can, oh, gotcha. Thank you. Probable cause December 18th, 2025, 9 a.m. Bond continued in these matters.
Thank you, Your Honor. Have a great day.
Court does call the cases of the People versus D'Angelo Armstead.
Morning, Your Honor. Any quick people? Right in.
Warren Brown, Deputy Defender of Payne Withen on behalf of Mr. Armstead. Mr. Armstead, please state your name for the record.
D'Angelo Armstead.
Thank you. Your Honor, today is the date and time set for probable cause conference. My client will be waiving his right to preliminary examination. And he is signing the.
In both cases?
Yes.
All right.
And understands that he does have the right to have a preliminary examination. I've talked to him about this case. He is Chief Trainee Act eligible. We do not believe that the prosecution objecting to that. So we are waiting over the circuit court. There's no agreement in place at this time.
Or is that correct? You're waiving your right to have a preliminary examination?
Yes.
You understand that that is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand that you'll not have that hearing. You'll proceed to circuit court for further resolution of these cases.
Yes.
People also waive their right.
Yes, Your Honor.
preliminary examination having been waived, defendant is bound over to circuit court on all 10 counts, 5 counts in each case. So,
Thank you. We acknowledge receiving information, waive its reading on the record.
your client stands mute at this time.
Yes.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all counts. Pretrial in these matters will be set for December 3rd, 2025, 1:30 before Judge Conlon.
May we address the issue of bond?
You may.
Thank you. Your Honor, this is about trust. We understand that in the past, other defendants have violated the court's trust, promised to return, and they never did. We can understand the court feels a little some way about that. However, in Mr. Armstead's case, these cases are somewhat aged. They're old. And he was a different person. He is now working. He has a home in the area. And having matured, he understands the necessity to building the court's trust and regaining the court's trust. And that's what he's here to do. He's going to regain the court's trust if the court will allow him to be released on a tether.
Response from the people.
Part of the reason why these cases are so old is because the defendant failed to appear for 2 years on bench warrant status.
How?
Found to be the same.
Housing.
That's what
It was over 2 years. It's like 2.5 years. Like 2 years, 8 months. Motion for bond reduction is denied. I'm gonna keep the bond where it is. I understand that he may have matured, but let's get these cases moving forward. All right, thank you.
Thank you.
I think they need to sign. Court does call the case of the people versus LaShawn Charles.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Requesting permission to practice under Michigan Court Rule 8.120 under the supervision of Attorney Stephanie Cannon on behalf of Ms. Charles.
We haven't seen you in a while.
I don't know, I haven't been on PCCs this semester, but it's good to see you, Your Honor.
Good to see you.
Yeah.
Sorry you're still with Cannon. Permission to practice is granted.
Thank you, Your Honor. Before we request an adjournment, may we approach?
Yes, you may.
Thank you, Your Honor.
Thank you.
Thank you, ma'am. Court does call the case, people versus Mary Barney.
Mr. Public Defender Chelsea Virgils with and on behalf of Mary Barney. Ms. Barney, please state your name.
Mary Barney?
All right, and you're requesting an adjournment?
Yes, we're awaiting discovery.
Same, man. All right, probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued.
Your Honor, may I briefly address bond?
What would a PCC be without you doing that? Go ahead.
Ms. Barney is wondering if you would consider allowing release to treatment. She's seeking some substance abuse treatment.
Substance abuse treatment.
Yes.
Any objection from the people?
Yes, Your Honor.
Okay.
I am familiar with Ms. Barney and she has spent some time in custody last year. This case involves her going to her ex's house, lighting his girlfriend's car on fire, and then pouring kerosene outside of the house where a child, a baby, was present. Thankfully, the house did not light on fire, but the vehicle did. So I have concerns about community safety should she be released to anywhere.
Your Honor, I understand the concern. Ms. Barney has spent some time in custody. However, these remain allegations at this time. She has struggled to admit she has an alcohol problem. However, I think that her getting treatment would be beneficial to both her children, and the community. So I asked the court to consider it.
Was alcohol a factor in these offenses, do you know?
I don't think so.
Well, at this point, I'm going to deny the request. And then, if you come up with some additional information for the court will consider it, but I'm not going to release a retrieve. All right. Bond will continue. Yeah. Denying release to treatment. Court calls case People versus Christopher Coyle.
Assistant Public Defender Jay Bellinger on behalf of Mr. Coyle, Your Honor. Mr. Coyle, can you please state your name for the record? My name is Christopher Coyle.
I have a plea form in front of me. Is that what we're doing?
We are, Your Honor.
Says he's going to plead guilty to the charge of domestic violence. He didn't put the maximum penalty in, but 93-day offense. Upon a successful plea to that charge, count one would be dismissed. The people and the defendant are in agreement to a sentence under 7694A. And it is my case, so we didn't need that. That's the court's full understanding of the agreement.
That is our understanding as well, Your Honor.
All right, may I have him sworn?
Raise your right hand. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Yeah.
I do.
State your name.
My name is Christopher Coyle.
All right. There it is. This court's understanding that you're going to plead guilty to the charge of domestic violence. That's a misdemeanor, punishable by up to 93 days of jail, $500 fine plus court cost. You understand that?
Yes.
Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as other rights.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today in the record to get you to plead? Anybody threaten you or coerce?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
On the date of October 7th, 2025, at the location of 3000 Woodland Hills Drive, Pittsfield Township, Washtenaw County, State of Michigan, what'd you do involving is it Elliot Everts, that makes you think that you're guilty?
I had a heated argument with her and I got aggressive and I pushed her.
All right. And you did that intentionally?
Yes.
All right. And who is she to you, or was she to
She's
you
my
at that
fiance.
time? Pardon?
She's my fiance.
Sir, I would have to advise you that if between the time of my acceptance of your plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that, sir?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's?
Satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1. Probation sentencing will be
December 15th at 1 p.m.
December 15th, 2025, 1 p.m. That's before me. Bond with its conditions will continue. Thank you.
Thank you. And he's free to go down to probation now and talk to them about setting up his pre-sentence interview.
Yeah, he's free to do that.
Okay. All
That's
right.
I'd order.
Thank you.
All right, thank you.
Yeah. All right. Go down.
Court calls the case, People versus Jeffrey Bluchinger. Probably messed up the name. Oh.
Stephanie Cannon on behalf of Mr. Buchinger. Could you please state your name for the record?
Jeffrey Buchinger.
Buchinger, Your Honor. The C is silent?
Yeah.
Okay. Your Honor, we are adjourning this, the prosecutor and I, we're working out some details. And we need past the 18th, is that correct?
Yes.
Past the 18th of
Yes.
this month.
Yes, Your Honor.
That's not a problem. Probable cause conference, December 4th, 2025, 9 AM.
Thank you, Your Honor.
Bond continued. Thank you.
Okay.
Court calls case People versus Carlton Cross.
Assistant Public Defender Chelsea Ritchie with and on behalf of Carlton Cross, who appears via Zoom. Mr. Cross, please state your name.
Carlton, Cross.
All right, I'll need a camera, sir.
All right, oh. Trying to, I don't know something.
No, that's him right now.
Yeah,
It sounds like him.
it's me. I'm trying to get the camera.
I'm sorry, Your Honor, we can practice for next.
Oh, there you go. We have it.
You have it?
Yep, I see you.
Okay. I'm sorry about this, sir.
No, it's okay. It's okay. You got it. Okay, what are we doing?
We're asking to adjourn for discovery.
Probable cause conference in this case will be adjourned December 18th, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
All right, thank you, sir.
Thank you so much, sir. Sorry about the trouble.
No, not a problem. That adjournment will give you time to practice your Zoom skills.
Yeah, exactly. Thank you, sir.
Take care. Court calls the case of People versus Lewis Burbanks. 2 cases.
Assistant Public Defender Jay Bellinger on behalf of Mr. Burbanks. Mr. Burbanks, can you please state your name for the record? Also yours, okay?
Okay. Lewis Burbanks. What are we doing?
Your Honor, my client does wish to set both of these matters for preliminary examination. With regard to the discovery, there is still some outstanding discovery on the resisting and obstructing case. I have explained to my client that he wouldn't be able to get an adjournment should we not have that by the date of the preliminary examination. He fully understands and acknowledges that. With regard to the other case, we appear to be complete.
Got it.
Talks to me after this, I will try to get that over as soon as possible.
Thank you.
Okay, what's missing on the resisting and obstructing?
I don't have any media whatsoever, so I imagine just body worn cam.
You understand that, sir?
Yes, sir.
And for what it's worth, Your Honor, I believe we are keeping these cases together. I'm not sure that my client wishes to run on the resisting and obstructing case, but may, so.
All right. Got it. Would people have their witnesses available the 25th? Preliminary examination in person will be set for November 25th, 2025. 9 AM before Judge Freshour.
And Your Honor, if I may address bond briefly.
Briefly.
Your Honor, my understanding is that in the domestic violence case, the bond is set at $150,000 cash surety bond. With regard to the resisting and obstructing, there is $100 on that matter. My client advises that he can stay at the Delana Center, which is right across the street from his job at West End Grill. My client at this time wishes only to go to Delana's and go to work 2 and 4. That's it. He doesn't wish to do anything further, no extracurriculars. One condition of his bond is that he wear a GPS tether should he post, and he is fully willing to comply with that, as well as any other conditions as set by the court. He's seeking a PR bond or alternatively a lower cash bond that he might have the ability to post and get back to work.
I have 4 assaultive offenses, including 3 charges of domestic violence self-defense. Is that what I'm looking? I don't need a response. Most for bond reductions denied. Bond will continue.
Understood, Your Honor. Thank you.
Thank you. You already did it. Court calls case of the People versus Charles Davis II.
Brian Bowen on behalf of Mr. Davis, approaching judge. While he
State your name for the record, please.
Charles Davis.
Your Honor, I'm asking for an adjournment. I gave Mr. Davis a pretty good amount of discovery to review today. There's about 45 or 50 videos that were produced. So just need a little bit of time.
Probable cause conference will be adjourned in this matter to December 18th, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thanks.
Court calls case of the people versus Jason Campbell.
Water Assistant Prosecuting Attorney for the People.
Who? Your name, sir?
Jason Brett Campbell.
All right, hold on a moment.
I'll take it, sir.
You got it. Okay. There's a request for an adjournment.
Yes, Your Honor, we are requesting an adjournment to track treatment progress.
Guess I'm not sure what that means. Is he in
Your Honor, there's
treatment at
already
this
been
time?
something signed. Client is awaiting release to treatment. I do believe any offer will be contingent on treatment.
I'm getting it.
He had a hold up Westland. Ms. W was trying to get him arraigned on that.
December 18th, 2025, 9 a.m. bond continued. Court calls case People versus Zachary Duran.
Ashley Feltus with People.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Duran, standing here to my right. State your name, Mr. Duran.
Zach Duran.
And you're requesting an adjournment.
Yes, sure. And I have received the paper discovery, and I was notified during the docket that we have received the video. I just had
Video.
a chance to look at it.
Probable cause conference in this matter will be adjourned to December 11th, 2025, 9 a.m. bond continued.
Your Honor,
Yes.
the victim, the defendant's father, is president of the courtroom and would like to address the court about bond conditions, specifically requesting contact.
You're requesting contact.
I'm opposed to any change in the bond.
You're opposed to.
I am, but.
All right. But he's, okay. So if he can have a seat over there, and where's Dad? Your name, sir?
Your Honor, my name is John Dorn.
All right. What did you want to tell the court?
I understand that there was a bond condition on him that he was to have no contact with me, and I am not opposed to him having contact with me. I don't either fear anything from him, or I might actually be able to help him. So I'm trying to still work with my son. So.
And does he live with you or?
Not at this time. He did, had been previously. It's been quite a while.
Okay, before you sit, what is the alleged connection between the offenses? Is it the invasion of the house?
To me, Your Honor, or?
Yes, that was
Thank
you.
you. Your Honor, my understanding is that the suspect broke into the home, damaged a lot of property, stole other property, and made some threats about potentially taking action against the victim, Mr. Doran.
Got it. Anything else you want to tell me, sir?
Nope, other than I just don't have any problem with having contact with him.
Okay, I may not allow it at this point until I can get through some stuff and take a look at it a little bit closer, given the allegations, but I understand.
Okay.
All right, thank you, sir.
Your Honor, the court said December 18th.
I think I said it would be 11.
I apologize.
December 11th. December 11th, 2025 at 9 a.m. At this point, you need to take your hands out of your pockets. At this point, I am not going to allow contact, given the circumstances, at least as I see them here and have heard them. I'll deny that request and bond will continue.
If I could be heard on another condition of bond, Judge?
Yes, sir.
Your Honor, I have had a chance to speak with Mr. Dorn about this matter. He is a sportsman. This is the opening weekend of deer season, of the firearm season. As a bond condition in this matter, he was required to relinquish his firearms.
And the deer arm too. I don't know what. Go ahead.
He was ordered to relinquish his firearms, which he did. We're asking that the court allow him to have in his possession one particular firearm so that he can go deer hunting this season. It's while it is the beginning of the season, it is a method a lot of folks use to provide meat over the course of the winter. We've identified the particular weapon that he would need to use. He has relinquished that to a friend of his. We'd ask that the court allow him to basically check that out and return it after each hunting session. Like I said, it's my understanding that the season starts this Saturday. It's been a long time and I never much did more than make chili. So I'm not exactly sure when it starts and ends.
I go out and hand guns to the deer so they could shoot back. Response from the people.
Your Honor, I am going to request the court continue the orders as currently set, the defendant not be in possession of any firearm. Do have concerns. I understand the defendant may also struggle with substance abuse, specifically with methamphetamine. I would ask the court just continue it for now. I'm very sensitive to the fact that is how a lot of people fill their freezers to go out and hunt. I can understand that. But in this specific situation, I'm going to ask the court continue it as it's currently set. Frankly, I'm also concerned that the firearm is with a friend and not in police custody, but I'm going to leave that as it is, just ask the court continue the conditions.
Yeah, why? Was he ordered to surrender firearms?
In looking at the file, it looks like there was a bond condition of no possession of firearms that was checked on the order that I looked at in the file, Judge. The pretrial release order. May we approach, Judge?
Yes, you may. You and that I'm going to the record to reflect. What I'm going to do at this time, the record to reflect, I had a brief bench conference. I am going to deny the request for that modification of bond. This bond will continue, and that is that he cannot possess any firearms.
All right, thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court calls the cases of the people versus John Devine.
And Stephanie Cannon on behalf of Mr. Devine, who is appearing to my right. Mr. Devine, could you please state your name for the record?
John Patrick Devine.
Thank you.
And Your Honor, we're asking for client to be released to treatment. I did email the prosecutor with this particular request earlier today. But in addition, we are asking for, we're asking actually that you set it for an exam.
Oh, all of them?
Mr. Devine, do you care which one goes first?
You want all of these cases set for exam?
Let's set them for exam, Your Honor. The 22 case, obviously, that one's the older one. So of course, we definitely want that one moving forward. There's a case from 2022.
I'm just asking, do you want them all set for exam?
Yes, yes, Your Honor. Sorry, yes. Please, if you would.
We'll have their witnesses available the 25th. Preliminary examination in these matters will be set for November 25th, 2025.
Pat, can you
12 noon. Those are before me.
Thank you.
And I'm going to refrain at this time from signing 12.
Thank you, Judge.
We need to, I'll sign that.
Thank you, Your Honor.
Thank you. Court calls case People versus Grant D'Souza
Can I spell this for
or
people?
Ducia, I think it was. Yeah, they he'll tell me.
Afternoon, Your Honor.
About time you show up.
Sorry.
No, go ahead.
Good morning, Your Honor. Veronica Glenn requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Public Defender Stephanie Cannon.
Glenn, permission to practice is granted.
Thank you.
Your name, sir?
Grant Matthew Duche.
Duche. That's right. I knew. All right, what are we doing on these cases?
That is a good question. We are requesting adjournment.
Do I have a green sheet?
There's an offer outstanding with the defendant to largely $100 with restitution in the amount of $10. That plea form was sent over, so we'll just leave that open to the next hearing.
Oh. So is there adjournment until we consider that, counsel?
No, I wasn't aware.
I was not aware of that.
Okay, so that means it's come over. They need to have a chat with you about what that means and everything. So I'll adjourn it out. Probable cause conference, December 4th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Thank you, sir.
I'm doing court on the 19th, Your Honor, for misdemeanor, and I can't make it. Can I reschedule that?
The 19th, who's that before?
You?
Oh, you got a Pittsfield case before me on the 19th?
Correct, Wednesday, yeah.
I don't have the file.
All right.
Can't make it. Why can't you make it?
I'm watching some dogs because friends of mine are going deer hunting. And I'm taking care of their house. Sorry. That's the time.
You know what? If somebody came and told me that, I'd say, no way. No way, you got to show up. But I get it. Ms. Weidling, who's your attorney on that? It's PD case? Is it assigned to Pate or Parony?
Parony.
Parony? Parony's his attorney? Then no. Okay. I appreciate you asking, sir. I really do.
Thank you.
So how long are they gonna be out hunting?
1 week.
A whole week?
Pretty much, yeah, unless they get done before that, but they'll probably be up there a whole week. 21st.
You know what? Okay. I'm not even gonna argue it. Ms. Weidling,
December 3rd.
we'll adjourn that to December 3rd for you.
Thank you very much, Your Honor.
All right, not a problem. Thank you for asking. Happy hunting. I'm gonna find me a fire. Court calls the case, People versus Dalton Hall.
Deputy Chief Public Defender playing with and on behalf of Mr. Hall who approaches the podium. Once you get here, please state your name for the record.
Got it.
My name is Dalton Hall.
Your Honor, today's date time set for the probable cause conference. My client will be waiving his right to preliminary examination. He'll be agreeing to be bound over to circuit court. He is signed waiver. I've had an opportunity to speak with him at length about this. Choice is knowingly and intelligently.
Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution?
Yes.
People also waive their right. Preliminary examination, having been waived, defendants bound over to circuit court on all 6 counts. Mr.
We acknowledge receipt of the information. We waive its reading on the record. My client will enter a plea of not guilty at this time.
Defendant having waived formal reading, pleading not guilty, court will enter those pleas. Pretrial in this matter will be set for
December 3rd at 1:30 with Judge Conlon.
December 3rd, 2025, 1:30 before Judge Conlon. Bond with its conditions will continue. Thank you. Yes. We're good. I don't care. Court does call the case, People versus Ayana Fan.
Here.
Ms. Fan, I need a camera, please.
Can you see me? Okay.
Yes, we now continue. State your name.
Ayana Pham.
Thank you.
And I believe Ms. Ikiri Akinruli has submitted a green sheet. She's asking for this.
Where is she?
She's next door with Judge Barr.
A preference of hers? Never mind. Sorry, I got it. How much? Okay. I see.
It was given December 18th.
Probable cause conference in this matter will be adjourned December 18th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case People versus Stephen Kimura.
Ash Phelps for the people.
Stephanie Cannon on behalf of Mr. Kimura, who is standing to my right. Mr. Kimura, could you please state your name for the record?
Stephen Kimura.
And Your Honor, my client is going to waive his right to a preliminary exam.
All right, he can sign the form. Sir, you're waiving your right to have a preliminary examination?
Yes, sir.
Okay, you don't have to do that because it'll pick it up from.
Okay, my bad.
Otherwise, you look like one of those little birds trying to get that water.
Like a bobblehead.
All right, yeah. All right, so you understand that in waiving your right to a preliminary examination, that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution.
Yes, Your Honor.
All right. People also waive the right.
We do, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1, 2, and 3 with 4 and 5 following.
That's perfect. Your Honor, my client has executed the waiver form. At this time, my client was stand mute as to the charge of formal reading.
Defendant having waived formal reading, standing mute to all 5 counts. Court will enter a not guilty plea. Pretrial will be set for
December 4th at 1:30 with Judge Slay.
December 4th, 2025, 1:30 before Judge Slay.
Your Honor, Mr. Kimura is, and maybe everything is just going to be moved, but all of his other cases are in front of Judge Hammoud.
I'm sorry?
All of his other cases are in front of Judge Hammoud.
So what do you want me to do?
I just was letting you know because I thought you might be interested. They'll get switched over.
What? I might be able to do what?
So it's gonna switch the move?
Yes.
So
That's right.
those, if for whatever reason it's set that way, they'll get it straightened
He
out
was
there.
concerned.
Why? He doesn't want to be before Judge Slay?
He
You want
loves
me
and
to-
respects her immensely.
It worried you, but Judge Slay worried
I
you?
never had her.
Huh?
Never had her.
You want me to tell her you don't like her?
No.
Oh, okay, no, all right, thanks.
Thank you so much, Your Honor.
Judge Hammoud's the correct judge? It's, all right, on this date?
No, November 24th.
November 24th, 2025. 1:30, you get your wish before Judge Hammoud.
Thank you, Your Honor.
I'll let her know that you like her better than.
Thank you, Your Honor.
No, not a problem.
You have a blessed day, man.
You do the same. Court calls the case, People versus Michael Getzenauer. She's gonna be.
Ash Phelps for the people.
Attorney Kara Rosengren on behalf of Mr. Gackenauer, who's appearing by Zoom.
Where is he? He's the one walking.
There we go. Can you hear me?
Yes.
Unmuted.
What's your name?
Michael Gokenauer.
Yes. All right, what are we doing?
Your Honor, an offer has been extended in this case, but we haven't had the opportunity to discuss it with Mr. Dockenauer, so we're just asking for a brief adjournment.
December 11th, 2025,
Perfect. Thank you, Your Honor.
9 a.m. bond continued. Thank you.
Thank you.
We'll be in touch, Mr. Dockenauer.
That
Court
sounds
calls
good.
case,
I'll
people
have my
first.
phone fixed tomorrow morning. Is there a number I can call you at?
Yeah, that's fine, Mr. Dockenauer. You're all set. We'll be in touch with you, okay?
All right, thanks.
Thank
You
you.
guys done?
Yes. thank
Okay,
you.
good.
Sorry.
Court calls the case, People versus Central Law. Oh,
Student Attorney Ronica
Back.
Glenn on behalf of Ms. Law. Ms. Law, can you state your name for the record? please?
Sandra Law.
Your Honor, we are requesting an adjournment in order to submit an order for inpatient treatment.
there's going to be an objection to inpatient treatment for this individual. I'm familiar with Miss Law. I'm going to let her go. So you can, I was asking out of courtesy.
I appreciate it. Thank you.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m.
Okay, thank you, Your Honor.
Bond continues. Thank you. Oh, Acting Ruleigh's back. She came to see you. She doesn't want to talk to me. That's fine. I don't care. I got thick skin. Court calls the case, People versus Letta Jones.
Good morning, Your Honor. Assistant Public Defender Donzie Lee on behalf of Ms. Jones, who stands to my right. Ms. Jones, can you state your name?
Lita Jones.
And we're going to be requesting adjournment today. My understanding is that the prosecutor office will be filing an alley.
That's correct.
Probable cause conference will be adjourned then to December 4th, 2025, 9 a.m. All right, thank you, Mr. Jones.
Come back.
Bond continue.
Your Honor, Ms. Jones just indicated to me she would like permission to travel. Well, this weekend, I believe, to Chicago.
Everywhere, every weekend.
Every weekend?
Yes, I gotta go.
Where are you going?
Everywhere.
Chicago?
Canada, Chicago.
Canada, Chicago? That's it?
That's it for now.
You don't go south?
No.
No? Canada, Chicago?
Chicago this weekend and Canada.
What'd you say?
Canada this week, Canada in 2 weekends and this weekend Chicago. Yes.
Sounds suspicious.
I did everything.
Ma'am. I should say no. I don't know. Yes, you may go. You may travel. All right, take care, Ms.
Bye,
Jones.
thank you.
Travel safely, please. Well, it's good. Just put it blank.
Okay.
Court does call the case of the People versus Kevin McCullough. Yeah.
Any further detail, Your Honor? Brian Bowling on behalf of Mr. McCullough is approaching, Judge. Can you state your name for the record, please?
Evan McCullough.
Your Honor, for purposes of the probable cause conference, we're asking that this matter be set for a preliminary examination, and then I would like to address bond if I may.
Yes, hold on. In discovery is complete.
Yes, to my knowledge.
People have their witnesses available the 25th.
We'll do our best, Your Honor.
Preliminary examination in person will be November 25th, 2025. 9 a.m. before Judge Fresh Hour. Yes.
Your Honor, when it comes to bond, there are some sensitive issues I would like to approach if you would allow.
You may. appear. Bond will be set in the amount of $10,000. Cash surety. That warrant will issue immediately.
Thank you, Your Honor.
Court calls the case People versus Andrew Patton.
Stephanie Can on behalf of Mr. Patton, who's approaching. Mr. Patton, when you are at the lectern, please state your name for the record.
Andrew Spencer Patton. Thank you, sir. This is also about missing or discovery.
Yes, Your Honor, we are asking for an adjournment due to discovery. But Your Honor, we'd also like to make a bond argument.
I'll adjourn the matter to December 4th. Go ahead, your bond argument.
Your Honor, we are asking for a personal recognizance bond on behalf of Mr. Patton. As previously mentioned, he is unemployed and unhoused. His advocate for LEAP is here. He spends the majority of his time participating in the LEAP harm reduction, a state-funded program. His advocate works with him, is working with him to get him back.
This is the same bond argument I heard before.
Is it, Your Honor?
Yeah.
I am stepping in. I think what the point here is that I understand that he was missing tests, and that just stems from indigency. He is working with LEAF, and we are working with the prosecutor to hopefully come up with a resolution to the short of trial. Because he would have done the testing, he just doesn't have the money for the testing. And Your Honor, just the keeping him housed because of indigency. My client just wants the court to know he's not going to use. If he could afford it, he'd gladly test.
I understand the factual circumstances. I don't need a response from the people. As with my last ruling, most for bond reductions tonight, bond will continue.
Thank you. Your Honor, what was that next court date? Oh, thank you, Your Honor.
Thank you. Court does call the case People versus Nicholas Harding.
Zach Vinio on behalf of Mr. Harding, Your Honor. Your Honor, I have been unsuccessful in my attempts to contact Mr. Harding, and I do not believe that he is present here today. We would ask for an adjournment.
That was on the 12th. All right. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $10,000 cash surety.
Understood, Your Honor.
That warrant will issue immediately if I didn't say so. Court does call the case of the People versus Robert Risa.
Student Attorney Kara Rosengren on behalf of Mr. Riso, who is approaching. Can you state your name for the record?
Robert Anthony Rizzo.
Going to be requesting that the court set a date for Mr. Rizzo's preliminary exam.
Discovery is complete.
Yes, to our knowledge.
People have their witnesses available the 25th.
We'll try, Your Honor. Thank you.
Preliminary examination in person set November 25th, 2025,
At noon too.
12 noon. That's before me.
Thank you, Your Honor.
Bond continued.
Thank you.
Court calls case of the People versus Bayan Haywood.
Assistant Defender Donnie Lebo from Mr. Haywood. Stands to my right. Mr. Haywood, can you please tell the court your name, sir?
Dion Haywood.
And Your Honor, we're going to be requesting an adjournment today. We're still waiting for some discovery in terms of surveillance footage.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor. Mr. Haywood did just ask me to address an element of his bond. He tells me that he needs to pick up his son from Fort Wayne, Indiana, and that was the 21st, sir?
26th.
On the 26th of this month. And to return to the 30th to drop him off.
Thank you. I have a parenting time agreement with my son and his mother, so I have to go to Fort Wayne and Indianapolis. So for Thanksgiving on the 26th, I go to Fort Wayne. I pick him up.
You
and I drop
you have it for Thanksgiving and then
Yeah, on the
Got it.
30th, I got to return.
turn. Okay, you have any objection to that?
No, does the defendant have a parenting order or custody order?
Yeah, it's with the friend of court.
All right, here's what I'm gonna do. Counsel, he needs to get a copy of that parenting order, get it over to the prosecutor's office. I will have no problem signing off if the parenting order reads as follows.
Thank you, Your Honor. Should I submit an order?
Yes.
Thank you.
Thank you. Court does call the case People versus Ronald Sims.
Assistant Public Defender Kelsey Deals with and on behalf of Ronald Sims.
Your name, sir?
Ronald Sims.
All right, what are we doing?
Your Honor, Mr. Sims at this time would waive his right to a preliminary exam.
Sir, is that correct?
Yes, sir.
You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes,
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
yes, ma'am.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is found over to circuit court on a single count.
We acknowledge receipt of the information, waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 25th at 1:30 with Judge Trump.
November 25th, 2025, 1:30, Judge County. Bond will continue.
Thank you, Your Honor.
Okay. Court calls the cases of the People versus Carlos Hicks.
Assistant Public Defender Jay Bellinger on behalf of Mr. Hicks, who approaches. Mr. Hicks, can you please state your name for the record?
How you doing, Judge? My name is Carlos Hicks.
My understanding is that my client no longer wishes for my office to represent him. He has advised that he wishes to represent himself. Part of the problem being is that he wishes to set for a final settlement conference here today. I explained to him the difference between that and a preliminary examination. However, he demands a final settlement conference.
Well, it wouldn't be set for a final settlement conference. You understand that, sir?
Yeah, but I got false information on the police report. They say I was armed with a gun, but I never had a gun.
Okay, sir, but I guess you don't want to be represented by the public defender's office?
I'll represent myself. I'll get my own.
You were going to represent yourself?
Yeah, I'll get my own lawyer.
So I suppose, Your Honor, we would.
How long will it take you to get your own lawyer?
Whenever I'm currently a client of Ozone, so I'm gonna talk to him right now to give me a lawyer.
All right, so what I'm going to do is I'm going to adjourn this out. I'm going to leave the PD on the case, come back with your lawyer.
All right.
And then we'll do it that way. So I'll adjourn this out to December 11th, 2025, 9 a.m. Maybe they'll explain to you why a final settlement conference is not what's set. Okay. Thank you.
For my client's benefit, Your Honor, I would advise as well that we were expecting additional discovery on this.
Sir, we're not done. No, go ahead.
My understanding is that we'll be in receipt of the additional and final remaining discovery as of today or tomorrow.
All right, thank you. Now you may move. No, don't do it. Just don't do it. Just don't. Let it go. Okay. The court calls the case People versus Donovan Smith.
Prosecuting attorney.
Assistant Public Defender Daffy Lube on behalf of Mr. Smith, who approaches from my right. Mr. Smith, can you state your name, sir?
Donovan Tyshawn Smith.
Thank you.
And I would like to set this man for preliminary examination. There is an issue of outstanding discovery with regard to some evidence that was submitted for forensic examination that has not yet been received by the prosecutor. Here I have explained that to Mr. Haywood, who indicated to me that he would like to proceed with preliminary examination in the absence of that having been provided.
And you understand that if you don't have that, that's not going to be a basis for adjournment.
Do you understand that, sir? We can't adjourn the proper cause, the preliminary examination, if we don't have that in by then. Could you say?
Yes.
What type of forensic?
DNA. I've reached out to the OIC to ask for an update as to how long it's going to take us to get that, but I have not received a response.
And there's been no preliminary DNA. I mean, I understand the full testing may not be done, but.
I have not received anything to that effect, Your Honor.
So you understand that, sir? If they don't have that evidence, you're not going to get an adjournment on this case.
So if no adjournment, what does that mean?
That means we would have the exam without that information. Like we talked about before.
will have the exam with no information. And is that not good?
It's just something you need to be aware of when you make this decision.
So if it's not ready by the next court date,
We still have the exam.
which is good.
Your Honor, can we pass this matter? Thank you very much.
Court calls the case, People versus Meyer Hughes.
Ash Phelps for the people.
She's unrepresented.
Yes, sir.
Meyer Hughes. Did she waive or what?
Pulling my notes up. I thought that we had appointed our last hearing. I'll try to reflect.
I don't have that, not here in any event, but so I'll issue a bench warrant on 10,000 cash surety.
Hey, Cedric,
Hello? Oh, no, that's the wrong person. Court does call the case of the People versus Randolph Taylor.
Public Defender Chelsea Gurgis with and on behalf of Randolph Taylor. Mr. Taylor, please state your name.
Randolph Taylor, yeah.
Your Honor, we are asking to adjourn to continue a plea discussion. Can I briefly address bonds?
Briefly.
He is being held on other matters on a lower cash bond that he cannot pay. I'm just asking the court to consider a low cash bond on this case as well. He has 510% on a fresh hour case and I believe 1,010% on a case with you.
Get a personal on this, doesn't he?
I thought it was,
Did he not show up?
I thought it was 10,000. I could be mistaken. I'm not aware of any failure to appears.
He didn't show up. That's why it's a 10,000 cash surety. He failed to appear.
Well, being he's held on other things, I can guarantee his appearance at the next court date.
Motion for bond reduction denied. He failed to appear, and he's got other matters pending. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Brandon Myers. Oh.
On behalf of Mr. Myers.
We don't have a date.
Hold on.
Hold on, 1 second.
Okay, let's do Myers. And then I'll do it.
Kenneth Overwater, Assistant Prosecuting Judge.
Stephanie Can on behalf of Mr. Myers, who is
Present.
attending by Zoom.
Yes. He stated his name, kind of.
Thank you, Your Honor. I did not get the opportunity to speak with him yesterday when I went to visit at the jail. I'm going to ask for an adjournment so I can have a meaningful conversation with my client to facilitate plea negotiations.
December 4th, 2025, 9 a.m. Bond continued. We're done with Mr. Myers. In Taylor, just so that you're aware, the December 11th was the date set for probable cause conference.
Thank you, Your Honor.
Court calls case People versus Marcus Jones.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Jones, Your Honor.
Not checked in. Huh?
Oh.
In the hall.
I believe Miss Iconrulli, Akiri Iconrulli has submitted a green sheet, Judge.
Has. Is that him?
He's approaching the podium, Judge.
Your name, sir?
Marcus Jones.
Thank you. What are we doing?
Your Honor, we're asking for an adjournment of this matter. I think we're trying to resolve it with the prosecutor.
Got it. Bench warrant, or not bench warrant, but probable cause conference will be adjourned to December 11th, 2025, 9 a.m. Bond.
Thank you, Your Honor.
All right, thank you, sir. Court calls case People versus Christopher Thaxton.
And the owner said, prosecuting attorney for people.
Zach Venue on behalf of Mr. Thaxton, who is present and approaching to my right. Mr. Thaxton, can you please state your name for the record?
Chris Thaxton. Thank you. What are we doing?
Okay, Your Honor, we would request an adjournment.
Do I have a green sheet?
No, Your Honor, we'll get the.
Okay, that needs to get to me. What's the reason? Reason you need the adjournment?
Your Honor, my client just right now spoke to me asking for an adjournment. We were going to set for an exam, but he said he has more information for me, so I would.
Oh, so additional, okay.
For additional information.
December 11th, 2025, 9 a.m. Bond continues.
Thank you.
Court calls case People versus Theophilus Smith. Is he exempt?
Warren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Smith. Mr. Smith, please state your name for the record.
Theophilus D'Angelo Smith Senior.
Your Honor, today is the date and time set for a competency review. Mr. Smith, during our phone calls, indicated he has been seen or reviewed. There is no updated report that we.
I have no updated report.
Your Honor, therefore, we will probably need your date, and hopefully this report will have been received at that time.
I'll adjourn the competency hearing date to.
Your Honor, what's the date of your most recent report, if I may inquire? I have one
The
from
most-
27th.
You have a report from the 27th?
I just found it. Yes, I do.
Oh, I do have one.
That one was
He said he's still incompetent.
It's still
Have you seen that?
incompetent, but likely to attain.
Right. Yeah, okay. He still remains incompetent. I do see it now in one file and not in the other, but whatever. All right, so I'll set a competency review hearing instead. Give me 90
February 12th.
for February 12th, 2025, 9 a.m.
Thank you, Your Honor. Mr. Smith does wish that I
Excuse me, Your Honor.
respond to this.
An address bond, go ahead.
Mr. Smith
Go
has
ahead,
asked
sir.
that the court please allow him to be released. The time he has spent incarcerated in these matters is more than his guidelines would have allowed. He indicates that he will return to all future court dates. He's asking that the court allow him to be released so that he can go home, that he can work and become employed. And
Are there other cases he's held on?
He's got these two cases, Your Honor, and I believe that he had just been sentenced on an assault with a dangerous weapon in Ann Arbor on January the 14th. And then this case had its first hearing on January 30th of 2025. So he had very recently had a felony assault conviction and then picked up, I believe arson was the one he picked up right after that.
No, excuse me, ma'am, what did you say? I got one case, I got a case, arson and a case of possession of narcotics in January 18, 2025. And that's my only case since since October 18, 2023. I only had one case in October 2023, and then January 25th, January 18, 2025, I caught two more cases, but during this time incarcerated, I got closer with God. I miss my family. I miss my mom, my brother. I miss talking to my kids. And Judge Simpson, if you will find it in your heart to give me a chance to really enter the community, I promise I will not let you down. I've been using my time wisely.
thank you, Mr. Smith. Your Honor.
Okay, the court, having considered everything and looking at things, the court is going to deny the request at this time. Motion for bond reduction denied, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Travis Kennard.
Michael Gaddy, Assistant Public Defender for Mr. Kennard, who's to my right, Judge.
Your name, sir?
Travis Kennard.
Thank you. You're requesting an adjournment.
Yes, Your Honor.
Probable cause conference will be adjourned. December 11th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court calls case People versus Christopher Whitaker.
Assistant Public Defender Jay Bellinger on behalf of Mr. Whitaker, who approaches Your Honor. Mr. Whitaker, can you please state your name for the record?
Christopher Whitaker.
And Your Honor, we have submitted a waiver form for the court, and I will let Mr. Overwater place our tentative offer on the record if he does.
In shape of the waiver, right to preliminary examination, people are agreeing to a resolution of this matter that would involve a sentence under the Homes Youth and Trainee Act in order to accommodate that. People would be dismissing the felony firearm charge as well as the armed robbery charge in exchange for pleas to other charges. Which charges he would be pleading to will be determined in circuit court with the circuit court APA. But the sum and substance of the agreement is that charges will be dismissed, allowing him to achieve a sentence under the Homes Youth and Trainee Act.
So you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing?
Yes, sir.
And you'll proceed to circuit court for further resolution.
Yes.
People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendant found over to circuit court on all 4 counts. Mr. Bellinger.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
November 25th at 1:30.
November 25th, 2025, 1:30, Judge Cook.
All right. Okay.
Bond continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case People versus Christopher Nieper.
Assistant Public Defender Jay Bellinger on behalf of Mr. Nieper, who appears via Zoom, Your Honor.
Christopher Nieper, Your Honor.
Thank you. Are you driving?
I'm parking, Your Honor.
That's a yes. Okay.
I'm parked now. Vehicle is off.
Thank you.
Thank
Go
you,
ahead.
Your Honor. Your Honor, we are requesting a 3-week adjournment. This should be the last adjournment we're requesting. However, my client did ask our office to send him snail mail media discovery on this matter. He has not yet received that. He would like to review that himself prior to consideration on an offer that's been made.
Probable cause conference will be adjourned December 18th without objection.
Thank you, Your Honor.
2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you. Court calls case People versus Patrick Williams.
I'm Bowling on behalf of Mr. Williams. State your name for the record, please.
Patrick Michael Williams.
Judge, I'm asking for an adjournment in this matter. I don't have any video related to this incident. I did bring it to Ms. Willenbring's attention. She indicated she was looking into it.
Get that video and make it available. So hopefully that will be sent over shortly.
Wonderful. Thank you.
Probable cause conference December 4th, 2025, 9 a.m.
Thank you, Judge.
Thank you. Bond continued. Court calls case of the People versus Walter Peterson.
Good afternoon, Your Honor.
That's okay. Brian Bowling on behalf of Mr. Peterson. Mr. Peterson, can you state your name for the record, please?
Walter K. Peterson.
Thank you, sir.
Judge, I'm asking for an adjournment in this matter as well. Looking for some video from the Meyer store involved in this incident.
Oh, you're looking from the Meyer store?
Yes, please. And Mr. Cook and I did discuss that. He said he's looking into it and hopefully we should have it shortly.
If I go to the 4th, will that work, you think?
Hopefully.
All right. December 4th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Thank you, sir.
December 4.
Court calls case People versus Kyle Wilson.
Stephanie Can on behalf of Mr. Wilson, who is approaching. Mr. Wilson, I'm going to stand on the case next door, so I'm gonna handle this case for you, okay? State your name for the record.
Kyle Wilson.
Thank you.
Your Honor, my client is asking for his exam,
Discovery complete.
to my knowledge.
People have their witnesses available the 25th. Preliminary examination in person, November 25th, 2025, 9 a.m. before Judge Freshour.
Your Honor, can I address mine?
You may.
Thank you. Your Honor, my client he has not violated any of his bond conditions. He's not attempted to reach out to the complaining witness in this case. We are asking for a PR bond, but if the court would even allow just a 10% privilege, that would at least put it somewhat in reach for my client. He's hoping to be out for the holidays. He does want to spend the holidays with his children, and he has a job still waiting for him. He has a sister that he can stay with, or other family friends. None of them are in Ypsilanti or Ann Arbor, so he won't even be in the county. And if the court is inclined to allow GPS tether without zone, my client will wear it gladly.
Response. I have, it looks like 75,000.
Okay. Your Honor, on 11/5, this sent a here on behalf of the people, a bond request was made at that. And this court stated that they were trying to raise bond if it was requested by the people.
That is correct.
And something like next time they request bond modification, we would likely ask that it be raised to $150,000 as it was originally requested. Defendant is currently on probation out of the 6th Circuit for GBH and domestic violence. The victim in this case is extremely scared of the defendant. Just reported 2 different strangulation events. And when officers attempted to arrest him, he resisted them. And he refused. Eventually, officers were trying to get to him. He was tensing up and pulling away. I have both serious concerns for the victim and law enforcement. So I'm going to request that the bond be increased to what we requested at $100,000.
Your Honor, and just to let you know, my client has let me know that that case was about to had this not happened because he had successfully completed his probation. The discharge
Which
papers
case?
were the, did you say Wayne case? 6th Circuit, yes. Oakland County. He said that was about to be dismissed because he had
Okay,
successfully
but
completed
the
everything.
facts and circumstances of this case were causing the court grave concern.
Okay,
And
so no.
the people are right. I had indicated that if you wanted me to take another look at it, that I would also consider the people's request to raise the bond. Having considered their request and having looked at it, everything, I think that the $75,000 bond is not an appropriate bond. I would raise the defendant's bond to $150,000 cash surety. Thank you.
Thank you so much, Your Honor.
Court does call the case, People versus Shaquille Tubbs.
Ashley Feltus for the people.
Brown deputy. Written on behalf of Mr. Shaquille Tubbs. Mr. Tubbs, please state your name for the record. You're speaking, but I can barely.
Yeah, no, I could hear him and I recognize Mr. Tubbs.
Okay. Your Honor, today's date and time set for competency review matter. We have received a report. Is the court in receipt of the report as well?
Yes, indicates that the defendant is incompetent but restorable.
We have no further evidence to present.
Any other?
No further evidence from the people who would stipulate to that report, ask the court to enter that finding. I will let the court know the defendant does have at least, I know of 2 more cases that are coming related to his behavior with Mr. Jail. So I do expect that we're going to see him back on new charges between now and the competency review date.
Got it. Okay. So the competency review in this matter,
February 12th.
February 12th, 2026, 9 AM.
Thank you, Your Honor.
Thank you.
The court should already have been provided with orders.
Yes, I've signed the orders.
Okay,
Thank you.
thank you very much.
Bond will continue. Thank you. Court does call the case of the people versus Devon Smith.
Assistant Public Defender Davi Lieb on behalf of Mr. Smith. Mr. Smith, could you state your name?
Donovan Tyshawn Smith.
Thank you, Your Honor. I did have a chance to speak to Mr. Smith some more. Mr. Smith indicates to me that he does understand that should we set this matter for exam without having that forensic evidence in our discovery, that we would not be able to have any further adjournments past that point, and that we would be proceeding with the exam. Mr. Smith further indicates to me that he would like to proceed with setting this matter for exam. Is that correct, Mr. Smith?
Yes.
People, other witnesses available the 25th?
Now, we've asked for a little bit more time just because I would like to try and get this DNA evidence.
Is there any objection?
Mr. Smith indicates to me that he would not like any greater time period than the court's indicated.
Preliminary examination will be set for November 25th, 2025, 9 AM. Is that right?
No.
12 noon before me.
Thank you, Your Honor.
Bond continue. Thank you. Court calls case of the people versus Merrick Lincecum.
Water Assistant Prosecuting Attorney for the People.
Zach Vinu on behalf of Mr. Lincecum, who I guess could be here via Zoom. Mr. Lincecum, are you there? Looks like.
And that checked in.
Okay. Then, Your Honor, I was in contact with Mr. Lincecum yesterday. He was planning on appearing via Zoom. I have not been able to get in contact with him today. Would request an adjournment.
Bench warrant will issue for defendant's failure to appear bond 10,000 cash surety. That warrant will issue immediately.
Understood, Your Honor.
Court calls case people versus Austin Lavistow.
Water Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Austin Lobosal, who appears via Zoom. Mr. Lobosal, please state your name.
Austin Lobosal.
We're asking to adjourn this PCC so that he can continue paying.
I will. Counsel approach, please. Right,
Thank you, Your Honor.
In this case, probable cause conference will be adjourned to December 11th, 2025, 9 AM. Bond continued.
Thank you, Your Honor.
Thank you.
Court does call the case people versus Khalid Muhammad. Mahmood. I'm sorry, it's Mahmood, not Muhammad.
Michael Getty, Assistant Public Defender on behalf of Mr. Mahmood, who's to my right. State your name, Mr. Mahmood.
Khalid Mahmood.
Thank you. What are we doing?
Your Honor, I've submitted a green sheet. We're asking for a brief adjournment so I can discuss this matter with Mr. Mahmood. At the last time, he thought he might retain counsel, but he's decided to stick with the PD's office.
All right. Probable cause conference, December 11th, 2025, 9 AM. Bond continued.
Thank you, Your Honor. Have a good day.
Court calls case people versus Stephen Javon.
Water Assistant Prosecuting Attorney for the People.
Stephanie Cannon on behalf of Mr. Javon, Your Honor. And I do have an adjournment request here. Once again.
He's refused.
Yes, he's refused. Yes. So he's set to get a competency done, Your Honor. It's my understanding he won't even leave to go do that. So I am not, I can just
Well,
ask
the
for. an adjourn-
people, you guys will have to discuss it. We've had to deal with this with Mr. Jolly before. So there's a method by which this can be. controlled.
Ken, are you going to point person for me?
I'll take.
Okay, thank you, Your Honor.
All right, I'll adjourn it to, if he doesn't want to come up, to January 8th.
Has the court received the competency evaluation? This one was completed.
October 28th.
That's correct. Your Honor.
He's unlikely. Yeah, but
I don't even.
here's my problem. He's got to be here for me to make the finding. So I have the report, but he's refusing. So we have to find a way to get him here.
Okay, I'll see how persuasive I can be.
Okay, you do that.
Thank you.
January 8th, 2026, 9 a.m. And Ms. Cannon, if you are persuasive with getting him up here, if you need it set at an earlier time, I don't have a problem. Contact Ms. Whiting, we'll move it up.
Thank you, Your Honor.
Thank you. Fine, continue. That's that block. And the next block starts like right now. Okay, but I'm gonna take a brief break and then we'll come back, get ourselves set up for the second block, and then we'll continue on courts and recess.
All right.